Lordship, this matter may be kindly be listed as motion tomorrow. We have filed it yesterday.
Friday.
Lordship, there is some urgency. The matter relates to awardment of contract by the NF Railway Authority. The petitioner is the lowest bidder, but due to reasons best known, the work has been allotted to respondent number 4. The petitioner fulfills all the eligibility criteria, Lordship. For tomorrow, Lordship.
I have filed a petition with Lord yesterday, that is regarding eviction. NS authority will construct a road, my lord, but others are not their land acquisition, but our land will not acquisition.
Your land?
Not acquisition, no assessment, nothing. And now they are coming to the my Pattal land also Miller and also some portion of the fixed land with Miller Mondir.
Men's 5.
Item কিমান আছে?
Men's 5.
Hello, this item 2.
This is really children market. Market. Well, it was a list earlier below Loshi.
No, now Men's 5. Eviction, no, eviction, Men's 5.
At children market, there is a
Settlement of market है.
there is again children market. It will be on Friday. For Friday.
Motion.
No, it is very admission. Earlier it was distributed motion.
Already many matters are directed to be listed Friday. Next week.
No, there is a holiday some days.
Yes.
There is
So
a
maybe on 11th or any day after.
any late.
Hello, this is item 2, that motion matter, when yesterday matter was heard. I don't, for some technical reason, the NIT itself has been cancelled yesterday.
Okay.
They had made my petition infructuous.
Yes, good enough. Without
All of us are. এইটুকু photo দিতে মানে
For my professional point of view, my lord, it is not good, but my lord, what is
second round.
my lord?
There is always a second round.
there is always.
দুই নম্বরও দিব। I had Mr. A. Goel, learned counsel for the petitioner, and Mr. D. Mojumdar, learned additional advocate general, assisted by Mr. S.R. Borua, learned junior government advocate, Assam for the respondents, full stop. The petitioner, the petition has been filed challenging a tender process initiated by publication of an expression of interest, page 66 for supply of soil. Expression of interest, this is soil for supply of soil. Bold लिखा है. Mr. Mojumdar, additional advocate general, has placed a cancellation of notice inviting EOI bearing EOI number so bearing number so issued by the Director Women and Child Development Assam, whereby the tender process initiated by the EOI number so has been cancelled. In view of cancellation of the EOI number so there is no necessity to for adjudication of the repetition. Repetition is accordingly closed.
But
a copy of the letter number so hearing number so on the subject so is kept as part of that.
My lord, as regard item number 5, your lordship, we are, my lord, now mediation is started among us, your lordship. So let the matter be taken after 8 weeks.
After
8 weeks, your in the meantime, we will try to separate. My learned friend is appearing and
Mr.
I am for respondent.
Okay, respondent.
responding. Petitioner already informed, my lord.
Okay.
Mr. Bora,
Mr. E. Goel, learned counsel for the
respondent number 4.
4. And Mr. B. Grodwas, learned
I was saying.
counsel representing the respondent IOC authorities have submitted that the parties are in the process of mediation to find out, to resolve the issues between them, and Mr. Goel has therefore paid that case be listed after 8 weeks. First of, he has submitted that the prayer is made with the consent of the learned counsel for the petition. First of, and having regard to the above submissions, the case is adjourned for a period of 8 weeks.
Date, if after 8 weeks, any date, my lord.
It will be listed after a period of, after 8 weeks. Only date to it.
DP.
Wait, your lordship, I beg to mention for listing of a writ petition for tomorrow, your lordship.
Tomorrow,
Yes, your lordship. The urgent
motion,
Motion matter, your lordship.
motion,
Motion matter,
subject.
issuance of advocate license, your lordship. The petitioner was,
What urgency?
the petitioner was not issued the advocate's license on the ground that criminal proceedings pending against her and her family. It was,
Okay, it can wait for 2 days. There is nothing that, nothing like eviction. Advocate can wait for 2 days, 5 days.
highly obliged.
If I may please, your lordship, I beg for listing to similar matters for orders.
Next week.
May I please, your lordship, I beg for,
Subject matter silent, check for you.
may I please, your lordship, I beg for withdrawal of 5 WBC matters. Lordship, the grievances of the petitioners have been mitigated, so the petitioners, they don't want to pursue the case anymore.
Okay. You are a counsel for the petition.
Yes.
You want today? You want today or any other day?
Today.
পরে যদি সব তাহলে বেলেগ একদিন দেখি। Yes.
I want to
Beg to
withdraw.
mention item number,
Lordship.
I beg to mention item number 4 of today's list, lordship.
Yes.
In this matter, I'm told that steps for extra copies were not received by the council or opposite side. Anytime maybe said there's some lapse on the part of the clerk, so I'll take fresh steps again today. So I need 2 weeks
Okay.
time.
On prayer of Mr. Dr. A2D, learned counsel for the petition, lays the case after 4 weeks. Mr. A. Kolidal and standing counsel, Industries and Commerce Department submitted that the counter affidavit on behalf of the respondent, Industries and Commerce Department authorities will be filed within 4 weeks' time. I think he will give,
I'll do today only.
Okay.
Much obliged.
raise the case after 4 weeks.
Item number 4 was just five was just mentioned.
Okay, BP Bora. BP Bora লিখে দিব, BP Bora number লিখে দিব। তেতিয়াহলে সেই consent নালাগে আৰু। হা? BP Bora and Mr. So-and-so have submitted the mediation.
Item number 1, top of the list matter.
Something,
My lord, I'm appearing online in this matter.
Dr.
Yes. My lord, I'm great. Am I audible, my lord?
Yes, just a minute.
Yes, ma'am.
Yes,
Yes. At the outset, my lord, I'm grateful that I'm allowed to appear virtually. This matter, this is with regard to tampering of a meter. And there was a allegation that there was an unauthorized use of electricity, and because of which there is a penalty which has been levied against us by way of an assessment order. Now, before I show the annexures, I'll just give a brief background of the case, what exactly has happened. On 22nd, 3rd, 2012, they have carried out an inspection. And in the inspection, there was nothing, then the meter was absolutely fine and seal was, it is the APDCL who is the custodian of the meter, they put the seal. Then again, after 3 months, there was another inspection carried out. In that also, the meter was found to be intact, the seal was absolutely fine. They said that some wires had been cut down, stripped off for 6 mm and 5 mm. And because of that, they sealed the meter and eventually they passed an order. In the initial order, they put a assessment for 12 months. Even though before 3 months only they have done an inspection and nothing was found to be there. Subsequently, when we make a complaint, when we replied to their provisional assessment, they have reduced it to 3 months. But then they have imposed a penalty of 12,68,000, somewhere around that. And subsequently, we filed an appeal. Now, my lord, what I will be likely to, I will produce before your lordship in the assessment order. There was nothing recorded, not even a single finding. What was the tampering, how it was done, then no statement was recorded. And finally, when arrived at a conclusion also, they have not even recorded that there was any unauthorized use of electricity. Subsequently, in the appeal, they tried to make out a case, but even then also, everything was out of a presumption because the meter, there was a CMRI that analysis which has to be evaluated that has not been done in the instant case. So that was the crux of the case. And then if my lord allows, I'll just take your lordship to the annexures of the case so that it will be convenient for your lordship. My lord may kindly see the first inspection report that is in page 17. That's annexure 1.
Mr. Pathak, it is audible to you?
Yes, Your Lordship.
Yes.
Yes, my lord. My lord, in page 17, annexure 1, that was the first inspection report of 22nd, 3rd, 2012. It is mentioned in the top right hand side, date and time of inspection 22nd, 3, 2012. In the said inspection report, at bottom it is said, a routine visit is done in the premises of the consumer for checking the metering condition and CMRI done for analysis. So, my lord may kindly notice that CMRI is very important here. CMRI is done for analysis and meeting details and reading details are as above. They have given the details and nothing was found. Now, there is a signature which is to be put by the representative of ours from the petitioner's side. He just checked that during inspection and checking and verified all new sales were put by ACP and found in intake. Our responsibility is only to see whether the seal was properly put or not. Beyond that, we don't have any other authority over the meter. Then, may I take your lordship to the other annexure, next annexure? Yes, my lord, then this is the second page is the original sheet. We have given a type copy in the previous page. And then my lord may kindly see 19, page number 19. That is the second inspection report, where the problem arose. In the second inspection report, the date is mentioned 16/6/2012.
Yes.
And at the bottom, at the same position, they've given a remarks. A routine visit is done to the consumer premises and CMRI is performed for checking the metering installation. It is found in the installation of cable meant for, there's a typing error. It should be some RS and S1 and S2 are stripped off over a length of 5 mm. These are the wire. There's a typo error. Stripped off over a length of 5 mm to 6 mm before entering the meter terminals inside the cabin box. The stripped off portion are found to be covered with pieces of PVC tapes, which are removed and sealed in presence of the consumer. Resealing is done without rectification of the metering system. So this is the allegation that some wire was stripped off, which was covered with PVC tapes. 6 mm, 5 mm area was stripped off from the meter. But however, the seal was found to be intact. May I take your lordship to the next page from here? The original is given below. It is not properly legible. Page 20 is the original one.
Yes.
Yes. Then, my lord, I'll take your lordship directly to the provisional assessment, which is in page 23. This is the type page. 24 is the original. My lord, may read the original only, page 24. Assessment bill for malpractice under clause 5A3 and 5A of 4 of Electricity Supply Code, notified by AERC. This is the only thing which has been given to me. Nothing has been mentioned that this is otherwise they name it to be assessment bill, but in the assessment, nothing is stated that why exactly this entire amount has been put on me. They have imposed a penalty of 53,76,720. They have calculated it for entire 12 months initially. The calculation is there, which says 212 into 215 into 200 into 5.2.
What does this figure mean?
This is a calculation given in the supply code.
Electricity.
In the supply code, the calculation is given, and I've say cross-checked it. There is nothing wrong in the this thing calculation.
What does it, 2 means what?
My lord,
2 means
who is most probably they are multiplying it with twice the amount.
then
That
12,
is- 12 is the period,
12 months.
12 months.
What is 215?
215 is the kilowatt, which is connection amount.
Connection
Yes, my lord.
15, okay, 250.
200 into 5.2 is as per the calculation. It is there in the supply code.
Okay. This is supply code.
Yes, my lord. I'll just show where it is there.
So twice is, I think, statutory.
My lord,
Yes.
Twice is statutory.
Cannot be, if the exact period cannot be determined, then the average consumption for the past 12 months into twice.
that is what is provided in the Electricity Act also.
215 is fixed,
That is his average consumption.
and this is from supply code.
Sir.
200 to 5.21.
Yes, yes.
These parameters are from supply code.
From the earlier supply.
Yes.
Then this is the provisional assessment bill which was prepared. I gave a reply. In page 25, my reply is there, where I specifically said in clause 3, my lord may kindly see, para 3, it is impossible to tamper with meter without breaking the seal which were found intact. Then I said that whatever there is in the inside,
Just mischief. It appears from the page 2019.
my lord. Yes, my lord.
Mischief had happened outside the meter, perhaps.
No, my lord, that is the entire problem. They have not yet come up.
Show me a picture of a meter. I cannot visualize
The
everything.
meter, your lordship, the
Do
seal.
you have any photo? I cannot visualize anything.
My lord, the best part is they should have come up with some photograph. There is no record of the photograph. They have recorded it.
You should have also come up. You have to stand on your own legs.
No, my lord, what I'm saying is correct. My lord is absolutely correct. What I'm saying, the surprising part is in the assessment.
I am not into the metering area, so I do not know.
My lord, that role should have been played by the assessing officer. Assessing officer should have recorded what was the fault in the meter, how it was. I'll show some judgment to that effect. That
But
what
why you are not making effort to explain it to me by diagram?
the effort will be there. It is the meter. Even if my lord may see there is some problem in the meter or something. The CMRI data is something which exactly explains everything. CMRI data, if there is a fault in the meter, if there was some unusual activity in the meter, it definitely will reflect it. That is why laboratory testing is done.
Mr.
Page Chaudhary, my lord.
Mr. Chaudhary, CMRI means what?
My lord, CMRI is a technical aspect. Even I have learned it from whatever judgment and data.
Meter reading instrument.
Common meter.
Common meter reading instrument.
That does not identify everything.
But then, my lord, there
Is sealing of, or what is stripping of 5 to 6 mm from each wire, 3 wires.
yes, my lord. No,
That's not detected by, I think, CMRI. Is it so?
In fact, the order of the appellate authority, it clearly states, your lordship, why it cannot be read by the CMRI.
This is because outside, before entering the meter terminal,
but my lord, before entering the terminal also, if something is done with the meter, then meter has to, that reading has to give something from the CMRI. That is why the laboratory test is done. My lord, otherwise, how do one justify? And then, my lord may kindly see, they'll have to come up with something to say that there is unauthorized use of electricity. Merely because they found some fault in the meter. Firstly, that it is not that every time the presumption has to be drawn against the
Chaudhary, page 25.
Yes, my lord. My lord, may kindly please see page 25, then,
Three does not appear to be in conformity with the allegation made by the ASC.
my lord.
There is question of no breaking of seal. Here is a question of stripping of a length of
Absolutely, my lord, but then if that was to be done by me,
ground and you have taken me to that, but I don't think this is the ground.
my lord, I will take further, I will show some relevant judgment on this aspect also, that how provisional, if the assessment order, it doesn't record anything, whether it is sustainable under the law or not. My lord, may kindly see para 7, that there is no finding that we have unauthorizedly connected any meter indicator on appear. Whereas any electric line to electricity is supplied to us or disconnected the same from time to time. The meter was found to be maliciously ensures and the index of such meter found to be fraudulently altered. The CMRI bears fact of our presentation. So the CMRI, we have taken the stand that they need to give us a copy of the CMRI report also. My lord, may kindly see then what was found by the AGM in the final assessment. Finding is very important in the final assessment. It says there was stripping of insulation of CT wires and RB phase inside the meter cabinet. Then it says, as per the report of TNC Dibrugarh, the seals in the metering cabinet were found to be intact. It was also found that TNC Division Dibrugarh inspected the premises of consumer on 22nd and CMRI data were taken for analysis and found no any abnormalities in the metering system. Till 22nd, they say no abnormalities found in CMRI. So if CMRI is relevant for them, what stopped them to check the CMRI for 16.6? They stopped it because nothing had come out in the CMRI. Otherwise, that is the basis for
What CMRI does?
My lord, it detects if there it goes for laboratory testing.
Detects everything.
Not everything, but my lord, if there is any unusual,
You should have come to the point.
yes, my lord.
This is the sealing is intact. That is the seal meter is sealed.
Yes.
But this is just below the cabinet. The stripping off was done below the cabinet. Right.
My lord.
Now this can be cited by naked eyes.
No, my lord, naked eyes it can be cited.
CMRI analysis.
CMRI analysis, my lord, determines whether there was any abnormal use of electricity. The electricity consumption has to be checked by CMRI. It is not the meter they check. They check the abnormality of the electricity consumption.
Now, in between March and June,
Yes, my lord.
did they visit your premises?
Yes, my lord. There is a meter reading which has been done. I will show it in the appellate order. Every day, every month, there were people.
There is another part, Mr. Chaudhary.
So, my lord, their employees came. They could have checked it. My lord, it is not that merely because there is. It is not the case anywhere that if we are.
Okay, carry on.
Yes, my lord. Then, my lord, may see in this order, they have not even said anything with regard to the incident of 16.6. This is the one-page assessment order which is passed by the assessing officer. Nothing is mentioned apart from the fact that 12 months period now they have converted to 3 months, because admittedly it was not for 12 months because 22nd there was no abnormalities found, and then they levied this amount. Out of this, when we went to appeal under section 127, we paid the 50% deposit. I don't know the status whether we paid the entire amount thereafter. But then, my lord, may kindly see appeal under section 127 is and page 28. We have taken the same stand what we have taken previously before the assessing officer. And now, my lord, may kindly see.
Let me read your grounds.
Yes, my lord. Yes, ma'am. We said that we never tempered the meter, and the finding of the inspection may be found to be not according to law. The alleged tampering as per a return was found inside the metering system and thus to be held responsible for same is unfair and unjustified. The CMRI having found the meter in order, there is no mala fide activity on our part having been found.
What is this 5A3 and 5A4, Mr. Pathak?
This is the clause.
Do you have the
Yes,
formula? Okay.
my lord. Then, my lord, I will take lordship directly to 33. This is more detailed in the appeal. Now, they've improvised the entire story. This could have been in the assessment order. Why my appeal is very short? Because nothing is there in the assessment order, so as to give me file a proper detailed appeal. But in the appellate order, they are recording the statement of each and every person who was present there. If my lord may see from page 34, they have recorded the inspection visit day. Whether my lord will like me to read the details, or I will point out the important relevant aspect of the order.
Okay, tell me your side of the story.
My lord. My lord, firstly, see page 35. They first say, page 35 at the beginning, that both the respondents submitted the written statement confirming the above facts. In his written statement, further stated that during inspection, in presence of DGM and engineers of the Dibrugarh, the appellant was asked to shift the metering installation to the entrance of the premises as per the norms of APDCL, but it was found that no action was taken by the consumer. I have never been given any such information previously. It is for the first time they are writing this thing. And then there is no proof also that they actually made such kind of information, has given any kind of information. Then they mention that CMRI downloaded data curve and temper information data 3-phase 3-wire of meter for record and analysis. So it was sent for analysis. The CMRI was sent for analysis. Then they say in next para, the respondent, namely the area manager, in his written statement confirmed that the assessment of compensation bill was raised as per rule. He further submitted that the energy consumption data of the said tea factory since March 2009 in support of his claim of interference of the metering system, and the consumption during this period of March 2012 to June was much lower than the corresponding period of the year 2009 and 10. So here also they have made a ball submission. They have not given any relevant record to this aspect, but still we replied that yes, there was less consumption considering the fact that the production was lesser during that period because of lesser rainfall during particular period. And also we have given a rejoinder that we have bought a new hair dryer because of which the consumption was a bit lesser. My lord, I have given the reply in the subsequent paragraph, but before that I will show what their contention. If my lord can skip this particular para, second para, and come to the last para. Here it says that AGM PNC division during hearing on 27 confirmed that seals were apparently found okay. He further displayed the snapshot of the same strip of cables inside and the meter cabinet, which was witnessed by all present during hearing. He stated with confidence that such type of uniform strip of cables was not done by his team during the inspection on 22nd. He further stated that the custodian of the metering cabinet was the appellant, and as such, no other person would have any interest on such interference of the metering system. So that is what is the presumption, that if a meter is found to be not correct, or if there is anything wrong in the meter, then obviously the presumption has to be drawn against the petitioner, which I say is to be absolutely illegal, my lord. There has to be some material which has been found which has to be found out to show that there was something fault on my part. Then my lord may kindly see that area manager admitted that the disconnected service connection is restored on.
Do you have a snapshot? Do you have a snapshot?
I can try, if it is available, I can try and ask them for it.
All these arguments will be cleaned by the snapshot.
Yes, what has actually happened, your lordship, is
No,
that-
let him.
yes, yes.
But
My lord may see,
the snapshot.
Today I do not have it.
my lord, then in page 36, they say he further submitted that the consumption data of key factories having similar connected load.
Page
Page 36.
76.
36, my lord. Page 30. Sorry, I'm sorry. The area manager, DIRCS, admitted that the disconnected service connection was restored on 36 only after payment of the 50% of the assessment bill after consultation with the DGM DEC. He further submitted that the consumption data of key factories having similar connected load in the nearby locality having similar weather conditions since February 2012 for comparing the consumption pattern. But then, my lord, nothing has been actually submitted. We don't even know to which tea factory they have compared us. Till date, in the affidavit also filed by them, they have not stated that there was any comparison to this effect. It's just a vague submission. These data revealed that three factories having less connected load were consuming more electricity than the appellant steel factory. Then finally, my lord, may kindly see the AGM TNC division submitted additional report. It is on the CMRI analysis of CMRI data, which also revealed that as the said meter was a three-phase, three-wire meter, the CT short circuiting case was not to be reflected, but other circumstantial evidences need to be considered as such. Abnormal uniform current 4 CT itself indicates malpractice done by the appellant.
So my thing is correct. CMR will not indicate this kind of malpractice.
My lord, this is only their submission, because if it doesn't indicate,
Common sense.
my lord,
Common sense, Mr. Chaudhary, common sense. The
my lord, I will,
indication of malpractice
yes, my
will
lord.
not be detected by CMRI.
No, my lord, I'm not on the malpractice to be detected by the CMI. I'm on
Where is
the
malpractice, Mr.
unauthorized, no. My lord, the assessment has to be basis of unauthorized use of electricity. The CMRI at least will verify whether there is abnormal use of
Case of
electricity.
tampering.
My lord,
Not
tempering,
inside the sealed meter,
yes, my lord.
not inside the sealed meter, the cables connected to the sealed meter.
But then if there was any tampering to that
Not
effect,
CMR analysis. This is not a case of CMR analysis.
my lord, then, my lord, may I just,
What is the difference between tampering and unauthorized use?
my lord, may I just submit? that
What is the
tampering-
definition? Let us see the definition, then we can understand.
My lord, tampering has to correlate with unauthorized. If they have imposed the penalty for tampering, then I can accept. I don't know whether I did the tampering or not, but they'll have to establish the fact that whether
There is a
unauthorized use of
definition of
electricity.
tampering.
So this is a use of unauthorized use of electricity. They have imposed on 126 and 126. I will
What
show
is
you.
unauthorized use of electricity?
Yes, my lord. This is the unauthorized use of electricity case. In
Now, what is the
126
definition?
my lord,
What is the definition under the statute?
my lord, 126, section 126 of Electricity Act. First of all, my lord, may also have to take note of the fact that in the assessment order, they have not written that there is any unauthorized use of electricity. The definition will be, my lord, in the definition part, there is no, it's not defined the unauthorized use of electricity in 126.
There in the explanation. you mentioned.
I have seen.
My lord, may kindly see 126, it specifically mentioned that in the assessment order, they'll have to specifically mention the unauthorized use of electricity. I'll show a judgment of this honorable court only, where it says, if it is not mentioned, then merely because seal was found to be tempered, that will not allow to levy any penalty or anything like that.
Yes.
Then, my lord, may kindly see on page 36, the last para. See Kandarpa Gohai, who usually collects monthly meter reading, during hearing admitted that the said strip of portion of the cables were near the entry point of the incoming supply cable, so it was not noticed during his monthly visit to the said premises for collecting the meter reading. He further confirmed that due to shortage of time and also visiting the said premises, normally in the evening hours, the minor differences, if any, existed in the painting in the hinge portion was also not noticed. This is what has been stated, but he also admitted the fact that he goes there and take the inspection. And my lord may kindly also notice one aspect that this is not,
Did they visit again on 31st August 2012?
my lord.
Did they visit again on 31st August 2012?
During that time, my meter was not, they were not, it was not in use. Because on 16th, 6, it happened, and after payment of the amount only, they have rectified allowed the meter to work.
Did you say anything about their visit on 31st August in the writ petition?
My lord, 31st August with regard to which particular incident?
Page 36 says on 31st August 2012, they went again to your premises and sealed the meter, resealed the meter, PVC, covered the PVC tabs tightly, resealed the meter cabinet, hinge position, optical port opening was done in presence of the authorized representative over the appellant.
On 36, my lord is saying, 30 July.
31st August.
Which one? I just missing this one. 31st August.
Did you say anything about that visit in your writ petition?
No, my lord, because we have said, because in the writ petition.
I have asked Mr. Chaudhary, I have asked you,
I get the point.
did you say anything about that visit in the writ petition? Did you say anything about that in the writ petition?
That I'll have to check, my lord. I will just find out if. But my lord, these all these aspects are subsequent development which has happened. But in the writ petition, of course.
This appeal was heard in presence of the owner. He participated actively in the appellate proceeding. Is it not?
But my lord, what I say is that.
Because appellants submissions and contentions are recorded.
My lord, may kindly note also one aspect, that this inspection was not carried out with respect to any incident of lesser consumption of energy. Initially, when they inspected, there was no allegation.
Answer to my queries, did you?
My lord, we have mentioned here
Yes
only.
or no? Simply yes or no.
My lord, may kindly see the reply in page 35 only. We say that during that period, the rainfall was lesser, and because of which the production was less.
No, Mr. I am asking you
Yes,
that
my lord.
have you made any statement as regards the incident of 31st August
No, my
2000?
lord. 21st incident, I'll have to check, but to my understanding, it is
No.
not there.
Okay.
I'll have to check it once again, but then I'll make a mention that we have specifically stated that why the period, why it was the consumption was lesser during March to June
I have
2000.
seen. We have traveled that paragraph.
Yes, ma'am. That was the explanation given by me. It is not that all the explanation has to be given by law. In the assessment, they had to give some explanation previously that why they have entered into this. So, my lord, CMRI have already shown. Kandarpa Goa is also shown that he visited the premises monthly. He did not see anything during that time. And finally, the finding is what my lord has said. This is the finding the court also noticed. May I read the finding? It is on page 37. Having gone through all the documents, arguments, and the snapshot, it is observed that stripping of those cables in the metering system was abnormal. Such type of work generally never done by meter management group, as they are trained and also experienced person. The prima facie evidence reveals that by doing such work, the interference in the metering system can be made easily and consumption can be manipulated. The benefit by doing such misdeed will be enjoyed none other than the appellant, causing loss of revenue to the respondent. The subsequent low consumption of the 22,000 still resealing as stated above corroborated the metering system was tempered. That is what my lord has put the question. The evidence in the snapshot, that is finding one naked strip of portion of the cable for such strip of cable, confirmed that the PVC taps were wrapped loosely to facilitate shifting of PVC wrapping for short circuiting through the optical port opening by expert hand with artificial means. I am therefore convinced that the appellant removed the hinges of the meter cabinet doors, keeping the seal intact with PVC taps loosely, refix the hinges and repaint the to camouflage. After making the said provision ready for interfering the meter system and CT short circuiting was done through the opening of the optical port window by artificial means, as and when required to reduce the actual consumption. By such act, the appellant restricted the actual consumption of the meter. This is what I am saying. If there was any restriction to the actual consumption of the meter, that will amount to unauthorized use of electricity. And CMRI, to my average understanding, my lord, it should have detected it. That if there was any abnormal use of electricity. I cannot go beyond that. I'm not a technical person to explain too much on that aspect.
Common sense does not say so, because of the malpractice, kind of alleged malpractice.
My lord,
It
my
is
lord, I'll not.
outside the seal meter. Meter seal was kept intact, but everything happened just
Outside the meter.
outside the meter. And I think what the picture I am having in my mind,
Yes, sir.
better.
My lord, the picture, problem is the picture always comes whenever there is a if there is any such situation arises. The
There is
picture
no
will be
doubt
that
that
pose of
what was taken in presence of everybody.
my lord, then I'll show one judgment. The same picture was there. There was a tampering in the meter. With the same picture, this honorable court has also passed an order saying that
I
provisional.
have seen the picture here.
My
I
lord,
have seen the picture, neither the petitioner.
no, picture, that imagination. I am saying about the picture, that
Imagination will not do.
imagination I am referring to.
Imagination will not carry the.
Because if my lord see the judgment of this honorable court, my lord will get the same imagination that there must be something, but then legally it has to be sustainable. Otherwise, any wrong in the meter, it will be a precedent that immediately the person who has the meter in his house will be held responsible for that. And there is no question of any challenging that order itself, because meter was tempered, so that person will be liable for penalty. There has to be some, because in the appellate they have everything, they have modified the statement. Till the assessment order, there was no order. Nothing was there. Now, no recording was given with regard to all these aspects. Now, my lord, may kindly say, I will show a judgment of this honorable court. That is,
Let the facts be clear.
yes, sir. My lord, why I'm saying that, why this judgment? Because the exact incident that happened with regard to tampering of the meter, and court said that if the assessment does not reflect anything with regard to unauthorized use of electricity, whether merely because there was some tampering in the meter, that will amount to an assessment under 166, 126. That is what I am.
Yes.
May I show the judgment? My lord, may I again have the idea that provisional assessment, they did not write anything. In the appeal only, if I again have to show that provisional assessment, it was in page 25, 26, they did not write anything on whatever lordship has read, that's an appellate order. There is a totally improvised story in the appeal, but in the assessment, nothing is recorded. Nowhere it is mentioned that what is their stand and how there was an authorized use. What subsequently after 31st August, there was higher consumption of electricity. None of their stand has been recorded in 26, and not even a single word is used whether there was any unauthorized use of electricity. Okay. Now, my lord, I'll request Praveen Bora to hand over the judgment, copy of the judgment of the High Court. It's a Rajastri Tea Industries Private Limited versus FPDCL. Citation, I will give it to Lordship. It's 2019 2 GLR 116. I've given a printout of the High Court only. I've not taken out the GLRs.
Yes.
My lord, may kindly see page para 9. May I read, my lord? Case of the petitioner is that it is engaged in the business of manufacture of sale of tea, the same tea company. Inspection of electrical installation in the premises of petitioner was carried out by personnel belonging to APDCL on 5/1/17. The inspection team found that meter cabinet box outer seal cut and refixed with glue during meter reading. Therefore, inspection team took the view. Here, meter was in fact tempered. Seal was tempered. Took the view that it was a case of tempering of the meter. Following the seal, the meter was sealed and thereafter seized. Petitioner was informed by APDCL authorities on 5/1/17 that evidence revealed that it was directly or indirectly involved in the act of malpractice as defined in 5.A.4.1 of the Assam Electricity Regulation. Accordingly, electricity supply of the premises of the petitioner was discontinued. The area manager, Dibrugarh, quantified the amount to be 54 lakhs. Then in para 12, they raised the provisional assessment. My lord, I'll just take your lordship to the submission which was made, para 17. 1. The final assessment order is bad in law as much as there is no finding on record by the assessing officer that there was unauthorized use of electricity by the petitioners. Para 17, my lord. Yes, my lord. Para 17, sub-para 1. The final assessment order is bad in law is that in as much as there is no finding on record by the assessing officer that there was unauthorized use of electricity by the petitioners. Finding of the unauthorized use of electricity is a sine qua non for invoking power under section 126 of 2003 Act. In the absence thereof, the assessment order would be nonetheless in the eye of law. Related contention is that provisional assessment was not as per requirement of section 126 of 2003 Act, inasmuch as no rule has been framed by government of Assam in this. That will, my lord, I will not rely on that. Then para 2(3), they have said with the distinguishing with relation to 126 and 135 section, which is not relevant here in this case because they have not registered any complaint under 135. Now, my lord may kindly see. I'll just first show what they have recorded in the assessment 29, para 29. At least in this assessment order, there is something recorded. Para 29, the last portion, the relevant portion of the final assessment order 4/2/2017 is extracted here under. And my lord may kindly see, at least they have recorded the statement of TNC division personnel. All these statements were recorded, and on the basis of that, they have given a bill amount. Then, my lord, may I show page para 30? That's a finding of the court. On a thorough consideration of the matter, in the considered opinion of the court, the final assessment order dated so and so framed cannot be sustained in law for the simple reason that there is no finding, prima facie or otherwise, that there was unauthorized use of electricity.
Let us see finding first. To reach your opinion based.
That is why I showed page 29.
Let us see.
Para 29, relevant portion of the final assessment order. That's a assessment order, my lord, not the appellate. The AGM TNC division submitted a DVD containing video along with mentioning 3 points with respect to ground of case. Metering installation is situated inside the factory premises. To reach the metering installation, the inspection team had to pass through 2 gates which were opened by consumers' personnel. The inspection was carried out in presence of consumer. The forensic test of the tempered seal and tempered meter, which is lying under police custody, Dibrugarh, may be concluded as desired by the consumer. Also, the consumer was shown as the narrow normal meter with steel plate by AGM TNC, which was found missing in consumer's meter during inspection on 5/1/2017. From the above, it was seen that consumer adopted malpractice by tempering the energy meter. Also, regarding written objection submitted by the appellant for considering assessment to 27/6/16 to 5/1/17, it may be stated that the MRI downloaded on 27/7/2016 does not reveal information of meter cover open, as the meter was non-DLMS. Hence, malpractice period could not be ascertained. No relief can be allowed in the provisional bill served for 12 months as per the clause under interference with metering system of electricity supply code. Hence, provisional bill amounting already served and may be treated as final. The consumer, however, may approach the appellate authority if so desired. I'll again show, my lord, if I want to see page 26 of our assessment order.
So you want to say that this is applicable?
Yes, my lord.
So reasonable opportunity is to be given.
No, it was not only the case of reasonable opportunity.
And the
But-
appellate order, then if you want this, then this will be remanded back. And if
My
you want to taste the appellate order, because appellate order, the parties were extensively hard.
My lord. No, my lord, in the assessment order,
Mr. Chaudhary's slight distinction in facts makes a whole lot of difference in the
my lord,
decision.
may,
Now,
may,
there is a question, two grounds.
yes, sir.
That no recording was found regarding unauthorized use of electricity. And secondly, that no opportunity of hearing was accorded. Right? Is this the case?
My lord,
And
here also it is the same case.
this is the stage.
Here
and-
also it is the same case as an
No,
explained.
Mr. Chaudhary.
Hello.
This is the stage, this order was passed when, at the stage of assessment.
My lord,
After the final assessment was
Yeah.
passed, there was no appeal.
my lord.
So this is not automatically applicable.
My lord, may I just submit on?
Mr. Chaudhary, you have crossed that stage and you have reached the appellate stage where a detailed order has been passed.
My lord, when the appellate
You
stage,
cannot go back, you cannot go back to that stage, assessment stage, right? And to say that now appellate order will not do this, judgment will apply.
no, my lord, I'll say why there is a reason for that.
Okay, I have heard. And anything?
One more, I'll just submit on that point, my lord. That assessment order, if does not reflect anything, then in my appeal, that is why I could not make any mention properly in the assessment order, out of that assessment order. And
This
whatever
is your case that you have not.
whatever is recorded in the appellate order,
What is your-
it's just
what
a
is-
statement.
Tell me, what is your case? That because the assessment order did not record and you were prevented from filing a proper appeal, or this is one line of submission. Second part is what you are submitting.
Yes, ma'am.
Which one you are?
My lord, I am submitting on both the part.
Both cannot go together.
My lord, that is what happened in this case. Both the part went together. In the appeal, I could have given my submission only when there is something in the assessment order. If nothing is written in the assessment order, merely because appellate authority record, they have not recorded, they have not given an opportunity of at least properly replying to what they have submitted. That submission which is recorded in the reply. in the-
Noted.
My lord, with regard to CMRI, I'll just show there's a Delhi High Court judgment. Whether if Lordship will like to look into it, it explains what is the CMRI and how it is detected. It's an electricity tempering of meter. I'll just show that judgment to at least convince your Lordship on that aspect that whether CMRI actually helps or not. Here also, even when CMRI actually gives a different figure, still court said that when there is no proper verification, you cannot every time universally put delegation on the person who is having the meter. I'll just, for 2 pages judgment, I'll just show it to your Lordship.
Oh, Mr. Chaudhary, common sense is that if something foreign is incorporated,
My lord,
something foreign is incorporated in the metering system, then CMRI can detect it.
my lord, that's something foreign. If
CMRI
I
analyzes,
cannot go with the,
it's not a case of something foreign.
my lord, I very well understand what your Lordship is saying. I go down to what Lordship is saying, but I'm just trying to point out one aspect. It cannot be universal. It cannot be applied universally. That merely.
CMRI has not been gone into here. Case of, it is not a case of CMRI analysis. Appellate
This is a
Appellate
absolute case of-
order.
there is a case of why CMRI is done only.
n number of manner by which tampering or unauthorized electricity
Can be ascertained. What happened in this case? They only checked it. It is only visible. The photographs also are not produced before your Lordship. They don't know anything. Or they have not said anything with regard to any of them.
don't have the snapshots with you.
They have not produced it before your Lordship till date.
You don't have the snapshots with you.
My lord, with
Tell
me.
me.
My lord, I have no instruction on that, but then
Make a categorical statement that you don't have the snapshot with you.
so I cannot make that statement because,
At any time.
my lord, may I just say one thing?
To me,
It cannot be
I'll
universal
definitely
that
ask him. Because that will clear everything.
my lord, I can try and bring it out. It's a 2012 incident. So I'll try to get the photograph if it is there.
The same, so that will indicate whether this CMRI, all these things should be gone into or not.
But my lord may keep that on record, that 2010 judgment of Delhi High Court. I'll not trouble your lordship much on that. My lord may keep that on record.
Because if I don't find that this is a case of CM, we have to go to the CMRI aspect, we will not go,
My lord.
right? We don't think prima facie, I go to it, the Delhi High Court judgment, if I think that that case
Yes, ma'am.
is somewhat identical to this case, that is a different matter, but otherwise, CMR analysis is not going to help you.
End of the day, it will be totally up to your lordship. I can maximum place my.
Prima facie, I'll go to the judgment. But
No,
if
prima facie, I just make a request with your lordship that prima facie, obviously it also occurs in my mind when I have not gone through all these cases. It also occurred in my mind that prima facie, if there is a tampering in the meter, then definitely the person who has the meter, who is the beneficial of.
I'm reading the Delhi High Court judgment.
My lord, I'm grateful to your lordship. It's the impugn speaking order. Para 1 only it says that how CMRI data revealed.
Let me read the judgment. It is short judgment.
Very short judgment.
Is it a case of writ petition after appeal?
My lord, I will just have a look.
See, Mr. Choudhury, there is a different thing. Once you commit it to the jurisdiction of the appellate authority and participate it in all your senses, right? Then you cannot revert back to that original or provisional order and to submit that now ignore the appellate order. Let us go back to the provisional order of
No,
assessment.
I'm not 100% saying that ignore the appellate order. I'm also justifying what has been wrongly recorded in the appellate order also. May I just check whether it is.
Mentioned in the meta inspection performance. Okay,
My lord, I'll not say anything further. I'll just conclude my. I'm thankful to your lordship for giving me this presence here.
Your A. Chaudhary.
K.
K. K.
K. Chaudhary.
K. Chaudhary. Yes, Mr. Pathak.
Lordship, those snapshots are not there. In the prayers made in this petition, they have only challenged the order passed by the appellate authority. The provisional assessment, the final assessment or the inspection report, they are not under challenge. The prayers are at page number 14 of the petition. Your Lordship. Only the order passed by the appellate authority and the revised bill of 13/12/2012, they are under challenge. And in the judgment of Rajshri Tea Industries relied on by my learned friend, two of the writ petitions were regarding a final assessment and one of them was regarding a provisional assessment. And in the two petitions,
How many?
there were three petitions, Your Lordship, which were
Three
decided,
petitions.
three petitions which were
By
decided.
the same party or different? Ganapati.
That is not discernible from the
Order
petition, Your Lordship.
disposed. Okay, primary challenge to assessment order, affirming the provisional assessment order, assessing the dues and consequential bill, provisional assessment order. Okay, all provisional or final?
Or provisional or
Not
final.
appeal.
Appeal, not in appeal. And in this petition, only the order of the appellate authority is under challenge. So since the appellate authority has, which is a quasi-judicial body, has passed an order, that order would have to be tested, Your Lordship, on the conditions, criteria laid down by the Honorable Supreme Court in a plethora of cases, but particularly in the Surya Dev Rai case where it was consolidated. So whether the authority which has passed that order, whether it acted in excess of its jurisdiction, whether it has acted, whether the principles of natural justice were duly followed or not, and whether in rendering its findings, it had ignored any possible evidence, any admissible evidence, or acted on the basis of evidence which is not admissible. So these are the three.
Some finding of Surya Rai is not distinguished.
It has been distinguished, but not these three, not on this aspect.
So acted exceeding jurisdiction.
Acted in excess of its jurisdiction. It has violated the principles of natural justice. And thirdly, it has either acted on the basis of inadmissible evidence or ignored admissible evidence. So, Your Lordship, the order of the appellate authority is at page number 33. So regarding the first two grounds, Your Lordship, excess of jurisdiction, that cannot be applicable in this case because this is the authority designated statutorily under section 127 to hear all objections against final assessment orders passed under section 126.
Is there any rules framed?
Rules have been framed, which I have just placed the
Let us see.
Yes. The copy is there before Your Lordship.
This one,
Yes, Your Lordship.
electricity rules or in this book?
It says electricity supply code and related matters regulations
This one?
2004. Yes, Your Lordship.
Okay.
First amendment of 2007.
Let us see.
Yes, Your Lordship. The provision for appeal is under clause 5.A.5,
5.1,
A.5 at page number 1223.
5.1223.
Page number 1223 at the bottom of the page,
Yes,
5.8.5.
yes, yes.
A consumer aggrieved by such assessment may appeal to the appellate authority as prescribed under section 127 of the Act, accompanied by a fee of ₹100 within a period of 7 days from the date of receipt of the assessment notice stroke bill under intimation to the office of issue by depositing the following amounts: interference with metering system, theft of electricity, 50% of the assessment bill, which he has done in this case, and for others 33.33%. So he has appealed to the authority which enjoys jurisdiction under the Act and the rules. So regarding jurisdiction, there cannot be any grievance of the petition. Now
Is
regard,
there anything, any rules regarding procedure to be
no,
followed? by the-
procedural rules have not been framed, your lordship. So the general principles of natural justice will apply, your lordship. And the order in that regard speaks for itself because it says 2 hearings were given, your lordship, and the petitioner was present. His submissions were recorded and dealt with, your lordship. Hearings were given on 25/7/2012 and 21/11/2012. It is reflected at page number 33.
So it consists of person who has knowledge of matters related to assessment of electricity charges.
Lordship. Yes,
Consists of person.
yes, yes, your lordship. They are
Who has
usually,
knowledge of matters related to assessment of electricity charges.
yes, your lordship.
Okay. Yes, what about,
Regarding the compliance with the principles of natural justice. So the order at page number 33 reflects that 2 hearings were given to the petitioner on 25/7/2012 and 21/11/2012.
Hmm.
So that is not his complaint. That cannot be his grievance, your lordship. The natural justice principles were not complied. Now regarding the materials on the basis of which the authority arrived at the findings which it finally did. The relevant portions, your lordship, are available at page number 35, your lordship. Yes, page number 35. 36, rather, your lordship.
36?
36. Because what has happened in this case, your lordship, in a nutshell is, there is a cabinet box within which there is a meter. The seals of the cabinet box were found okay. This is the seal which is referring to. But inside the cabinet box, the 3 wires which lead to the meter, those wires are found to be tampered. Now his case is, if the seals are okay, then how could I have had access to the meter to tamper with the wires? Now what is the authority said on this? I'll read the second paragraph at page number 36, your lordship. The AGM Transmission and Commission Division during hearing on 21/11/2012 submitted additional report on further analysis of CMRI data, which also revealed that as the said meter was a 3-phase 3-wire meter, the CT short circuiting cases were not to be reflected, but other circumstantial evidences needs to be considered. As such, abnormal uniform cut in the 4 CT cables itself indicates malpractices done by the appellant. Shri Bhattakur, the Deputy Manager, Transmission and Commission Division, categorically stated that the said PVC wrappings in the stripped off portion of the cables were found in such loose condition that those wrapping could be shifted as per requirement of the appellant for short circuiting the CTs by using artificial means through the optical port which was not sealed. It was also specifically mentioned by Shri Bhattakur that during their earlier visits to the said factory, the main gates were never opened quickly. The team had to wait at the gate for a long time. He further stated that the color of the outer cabinet of the meter box was quite different and the color of the hinged portion was found to be freshly painted, which indicates that the hinges were re-welded and repainted. Shri Bhattakur further stated that the said naked portions of the cable in the meter box, which were left as is where is conditioned on 16/6/2012, were finally covered with PVC tapes tightly and resealing of the meter cabinet hinged portion. An optical port opening was done on 31/8/2012 in presence of the authorized representative of the appellant, and the consumption of energy since then increased to normal quantity. On the basis of this, your lordship, at page number 37 is how the authority has appreciated this material. Having gone through the documents, arguments, and snapshots, it is observed that the stripping of these cables in the metering system was abnormal. Such type of work generally never done by the metering management group, as they are trained and also experienced persons. The prima facie evidence reveals that by doing such work, the interference in the metering system can be made easily and the consumption can be manipulated. The benefit of doing such misdeeds will be enjoyed by none other than the appellant, causing loss of revenue to the respondent. The subsequent low consumption after 22/3/2012, that is the first inspection, till resealing as stated above, corroborated that the metering system was tempered. The evidence in the snapshots, that is finding one naked stripped off portion of cable out of 4 such stripped off cable, confirming that the PVC tapes were wrapped loosely to facilitate shifting of PVC wrapping for short circuiting through the optical port opening by expert hand with artificial means. I am therefore convinced that the appellant removed the hinges of the inner meter cabinet doors, keeping the seals intact, and stripped off the said metering cables uniformly, and then wrapped the naked portion with PVC tapes loosely, refixed the hinges, and repainted the camouflage. After making the said provision ready for interfering with the metering system, and CT short circuiting was done through the opening of the optical port window by artificial means as and when required to reduce actual consumption. By such act, the appellant restricted the actual consumption of the meter and caused loss of revenue of APDCL. Being custodian of the metering cabinet box and the equipments, the appellant's ignorance in the said interference is not acceptable. The appellant cannot shake off his responsibility of such malpractice. In view of the above, it is concluded that the final assessment bill of rupees so and so raised by the area manager, DIRCA, needs no review. The appeal is therefore rejected, and the final order passed by the assessing officer is upheld. The appellant is directed to pay the balance of 50% of the assessment bill dated 22/6/2012 with surcharge as per the existing rules within 15 days of the date of order. Let the order be served to all concerned. So now, Your Lordship, on the basis of the materials available, the appellate authority has arrived at certain findings. Now, whether this court, on the basis of averments made by the petitioner, would like to reverse those findings, Your Lordship. Just before going to that, Your Lordship, there is one aspect. The petitioner has repeatedly made out a claim that he cannot be blamed for any tampering of the meter since he has not done it. Now, there is a specific provision under this regulation
Yes.
which says clause 4.2.1.2.5, page 1207, Your Lordship.
1207.
1207. 4.2.1.2.5. The second,
Okay.
it specifically says that the consumer shall be responsible for safe custody of the meter, cutout, MCB, CB, etc., except in cases where such meter, cutout, MCB, CB are installed outside the premises of the consumer. In this case, it is inside his premise, so he is responsible, and that is why the appellate authority said that he is the custodian of the meter and he cannot shirk off his responsibility. So, Lordship, I'd like to place few judgments, Your Lordship. First, Your Lordship, the judgment of Surya Dev Rai, 2003 6 SCC 675. I'll rely on the final paragraph where the principles have been laid down.
Paragraph.
Paragraph 38, Your Lordship.
This is a comparison. 227 and
We primarily
Rai.
comparison, but
better you should have produced something on Sarchura only.
but the principles of Sashira have been somewhat laid down, Your Lordship.
We have to screen the things for Sarchura.
These I'll just point
Leaving
out,
aside 227.
I'll point Your Lordship out to the exact paragraphs, Your Lordship. I'll try and 38.3, Your Lordship.
There are so many judgments about
There
Sarchura
are, Your Lordship.
alone.
On Sashira.
Why you have chosen this one? Anyway,
38,
three, subsequent three perhaps.
38.3 is, Your Lordship. 38(3), a certiorari under Article 226 of the Constitution is issued for correcting gross errors of jurisdiction. That is when a subordinate court is found to have acted without jurisdiction, that is by assuming jurisdiction where there exists none, in excess of its jurisdiction by overstepping or crossing the limits of its jurisdiction, or acting in flagrant disregard of laws or the rules of procedure, or acting in violation of principles of natural justice where there is no procedure specified, thereby occasioning the failure of justice. Then number 5 also, Your Lordship, subpara 5. Be it a writ of certiorari or the exercise of supervisory jurisdiction, none is available to correct mere errors of fact or of law unless the following requirements are satisfied. The error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law, and 2, grave injustice or gross failure of justice has occasioned thereby. And number 6, Your Lordship, a patent error is an error which is self-evident, that is, which can be perceived or demonstrated without involving into any lengthy or complicated argument or long-drawn process of reasoning, where two inferences are reasonably possible and the subordinate court has chosen to take one view, the error cannot be called gross or patent. And then subpara 8, Your Lordship. The High Court, in exercise of its certiorari or supervisory jurisdiction, will not convert itself into a court of appeal and indulge in reappreciation or evaluation of evidence, or correct errors in drawing inferences, or correct errors of a mere formal or technical character. And I'm relying on another judgment, Your Lordship, in Swaran Singh. This is on 226 specifically. This is 1976 to SCC 868.
Yes,
Paragraph number 13, Your Lordship.
13.
13. In regard to a finding of fact recorded by an inferior tribunal, a writ of certiorari can be issued only if, in recording such a finding, the tribunal has acted on evidence which is legally inadmissible, or has refused to admit admissible evidence, or if the finding is not supported by any evidence at all, because in such cases the error amounts to an error of law. The writ jurisdiction extends only to cases where orders are passed by inferior courts or tribunals in excess of their jurisdiction, or as a result of the refusal to exercise jurisdiction vested in them, or they acted illegally or improperly in the exercise of their jurisdiction, causing grave miscarriage of justice. Now, on these principles, Your Lordship, but without discussing this case laws, a coordinate bench was pleased to dispose of a similar matter when order of an appellate authority was under challenge. This is WPC 6237 of 2013. Order dated 14, judgment dated 14 to 2019.
Yes.
Paragraph numbers 14 and 15 at the bottom of the last paragraph, Your Lordship. 14 and 15 at the last page. From the above, it is evident that the appellate authority has come to a definite finding that there was tampering in the metering system, and the benefit accrued from such tampering was enjoyed by the petitioner. Such tampering of the meter would be construed to be unauthorized use of electricity, as defined under subsection B of Section 6 of Electricity Act 2003, which would enable invocation of the powers under subsection 1 of Section 126. In such circumstances, it cannot be said that the assessing authority has acted beyond jurisdiction. The impugned appellate order cannot be faulted on the well-recognized grounds for invoking certiorari jurisdiction under Article 226 of the Constitution of India. In such circumstances, the court finds no merit in the impugned challenge. So, Your Lordship, my submission would be in a nutshell is that the provisional assessment, the inspection report and the final assessment are not under challenge. Only the order of appellate authority is under challenge. And that too, the grounds actually taken in the petition, not the grounds taken during arguments, are twofold, Your Lordship. One, they have said that the tampering that was done in their meter was done by people from APDCL only, that they are not responsible. But that, your lordship, since there is a presumption against them under the supply code, that they cannot shirk away from. And the second ground which they had sought to take, but which was not urged by my learned friend, perhaps is not relying on it, that since these are quasi-criminal proceedings, so the degree of proof has to be strict, your lordship. But there are judgments of this court that these are not quasi-criminal proceedings, your lordship. Under 126, your lordship, only the
It
electricity
is
charges.
135.
If it is 135, it is criminal. But that is my submission. That is all. Because these grounds were not taken in the petition. Regarding defects in regarding the provisional assessment, regarding the final assessment, about the reasons in reasoning in the order. Because the petitions are paragraph 11 and 13, they only speak about these two grounds, your lordship.
Yes.
This is a jurisdictional error. So even if it is not taken in the writ petition, I can very much argue that point, whether the assessment order actually has passed the reasoned order or not. It's based on section 126, doesn't have anything on facts of the case. So in fact, the judgment which has also been recently been passed, which I have shown it to your lordship, that was passed subsequently. So on the basis of that judgment, the registry, I'm relying and challenging the provisional order.
Which
And one-
judgment? Which
that
judgment?
registry,
Registry was passed
it was on 19/10/2018.
19/10/2018.
Yes, ma'am. So I found it relevant, so I produced it to your lordship on the ground.
The judgment Mr. Pathak relies on is of 14/2/2009.
14 to 2019. OD judgments are on a different footing.
Different, well, I'm just saying why I have taken this ground, the ground I am mentioning. And once I challenge that appellate order, if the appellate order is set aside, then anyways, everything goes out. That, my lord, I don't have to challenge each and every order separately in the prayer. And with regard to that hinges, that I'm thankful to my colleague that he has explained. Actually, it was not clear how it was done. That hinges were removed and then it was colored. There is nothing. It was just a submission. At that time of hearing, a submission was made, and court took the presumption and imagination that this must have been happening. So this is what exactly has been observed by the appellate court.
Otherwise, page 37
Yes, ma'am.
of the appellate order,
Yes, ma'am.
he records the findings, right?
Yes, yes, ma'am. He records a submission. It is
No.
not even clear that whether this submission was anywhere there.
Page 37.
Yes, ma'am.
He records whatever his observation is as regards the merit of the appeal. Page 37.
No, my lord, why I'm saying that hinges, he said that he is sure, convinced that the appellant had removed the hinges. Now, how he has arrived into this finding is arrived by page 36, where Bolthakur submits. It's like a evidence. It's not that I get an opportunity of cross-examination or something. He submits that.
No, Mr. Toruri, page 37,
Yes, ma'am.
about 8 line or 9 line, he really makes an observation about the evidence in the snapshots.
Yes.
Independent analysis of the snapshot, which I pointed out at the very beginning. That
Oh,
we
my lord.
cleans the issue.
There is no submission from my part. My lord may not take it that I am disputing to that effect. Because once inspection report it is signed by my employee, I cannot say that there was nothing as such. In the inspection report,
Open for you, that is not open for you.
I am not objecting it. I am saying because there was some mistake in it, whether the entire presumption will be drawn against me. That is what is my case. Because they have improvised their story.
1
In
minute.
the inspection.
Who are counsels available for other cases? Mr. Dr. Saraf, you are here for some case?
I think.
But the item number 3 minutes.
3. Other counsel is ready?
Yes.
Okay. Any other cases? I'll just ask for your information. Any other cases?
Item 6, madam. Item 6.
6. What about 7?
Yes.
7 will be done.
No, no. Yes, today.
7 will be done. Okay, we'll find out the time. Mr. Chaudhary, your associate is here.
Yes, my lord.
If I find the time, I'll dictate. If I don't find the time, I'll reserve.
Well,
Am I clear?
Very well.
Because there is another.
Very well.
Well, I'm highly obliged, my lord.
Go ahead. Okay, নামটা লিখি দেবো। A. Chaudhary and Borua, P.K. Borua. Petitioner, K.P. Patna.
My lord K. Chaudhary.
A. Chaudhary,
I thought my lord said A.
A. Chaudhary, P.K. Borua. P.K. Bora, petitioner, K.P. Patna. Sending us a petition. Well, if I find the time during the course of the I'll dictate.
My lord,
Otherwise, I have to do something,
Very well.
right?
highly obliged.
এটা খুঁজিব পারলে আমার dictation করি, নাহলে কি করে করতে পারছি না? But no more hearing.
Yes.
Before start, then shall I take the break for 2-3 minutes?
In this judgment, this honorable court said, my lord, that the claims which were submitted on a particular date, that is to be construed to be the date of the submission of the claims. And even if certain informations are to be collected also, then also the time period cannot be calculated. And also said that the 2 years period which is fixed, that is for the purpose of convenience and only for the speedy this one. And I may take it also, my lord, to the para 18. Or I will take it 16 first. The question which arises for consideration is whether the petitioner's claim of transport subsidy for the period from so and so can be said to be time barred, and whether on this ground the claim can be rejected.
Para 16.
16.
Yes.
As has been held noticed above, the petitioner submitted his claim in composite form for the aforesaid period before the authority, which was received on 14/11/2005. The composite claim was submitted because the subsidy amount claimed were small. Bearing the period from so and so, the composite claim for the rest of the periods was within 1 year period. However, the claim was returned back to the petitioner on 5/11/2012 for resubmission on quarterly basis, which was done by the petitioner on 14/12/2006. The delay in resubmission of the proposal for quarterly basis was explained by the petitioner on account of ill health of the company chairman, who was out of station because of the aforesaid reason. However, the rejection of the petitioner claim by the respondents by auditor so and so to the petition does not disclose any consideration of the reasons furnished by the petitioner. It also does not reveal consideration of the fact that the petitioner had initially submitted the proposal in composite form on 14/11/2005. The transport subsidy scheme is a part of the government initiative to encourage the industrialization in what are called lesser developed region of the country, and thereby accelerate the economic development of such areas. Objective of such scheme deemed beneficial, reasonable and liberal approach is required to be taken while implementing such a scheme. Of course, the implementing agency have to be alert to ensure that bogus or stale claims are not entertained. This court understands that the time limit of 1 year prescribed by authority for grant of transport subsidy is for administrative convenience and to eliminate belated claims or claims which are not genuine. This time limit of 1 year as prescribed is not an inflexible rule and is capable of suitable relaxation in appropriate situations. Coming back to the case in hand, it is clear from the pleadings and the stand taken by the respondent that the entitlement of the petitioner to receive transport subsidy is not disputed. The objection only is on the ground of delay. However, in view of the facts and circumstances as discussed above, the court is of the considered opinion that the claim was initially submitted and so, there was no delay in submission of the claim of transport subsidy by the petitioner for the period in question, except for the period so, by which period there was a delay of almost 1.5 months. In view of the conclusion reached, a detailed discussion on the cited judgments is considered not necessary. Following the discussion made above, this petition is therefore allowed by directing the respondent to release the transport subsidy amount of the petitioner and be found due to some period and so by following the prescribed procedure within 6 months from date on so. Now, in the case the petitioner also, the claims were filed within time. There was nothing beyond that. And you'll also find there is one letter because the claims were just produced before the authorities, by the industry department belatedly. You can see page 38. It says, with reference to the above, I am directed to say that you have forwarded the transport subsidy claim in respect to so from on so and received the claim in the commissionerate on 5/10/2006. Though the unit has submitted this claim of transport subsidy in the period so on 11/21/11/2005. So there is a gap of 1 year, 2 months, 2 days, which is objected and rejected by the SLC meeting held on so. You are therefore requested to furnish reply as regards the cause of the delay of the forwarding the transport subsidy claim to the commissionerate.
Where is the meeting, SLC meeting?
Well, SLC meeting, you'll also find that I will enclose the minutes at page 39.
Here it mentions 25/3/2008
My lord.
and page 39 says 33/2009. Which one is correct? This page 38,
My lord.
SLC meeting held on 25/3/2008. It was rejected. But page 39 is 33/2009. Meeting date.
My lord. My lord, on 28/9/2006.
25/3/2008 as per page 30.
My lord. 25/3/2008.
And this meeting, page 39, second line, held on 33/2009.
You also may kindly see the page 68,
68.
the relevant part of this minus. My
Yes,
case,
sir.
to Imami Limited.
Hmm.
These details of registration number so. The-
15/6. It was submission of.
The claims for the following periods were submitted in the specified time at DICC.
Which
However,
one is the,
my lord,
for which period?
the periods are mentioned in the bottom, my lord, 1/10/2006 to 31/12/2006.
These are the periods your claim is rejected.
It was submitting time. However, due to non-submission of some important documents and clarification of certain matters, the claims could not be placed before the SLC within the specified time of 2 years from the date of the incurring expenditure. In view of the above, the SLC advised members secretary to take up the matter with the DIPP Government of India. That's all. Now, you know, in the affirmative position, also they are saying the same thing. And also find the affirmative position,
Page 38.
my lord.
These dates are not reflected here. Is 38 date, or the dates mentioned is this. But 1/10/2004. Page 38 relates to
14 and
1/4/2004 to 31/12/2004.
this is for the,
No, page 38.
Yes,
This is a claim pertaining to 1 quarter
this is 31/10/2004.
to 31/12/2004.
2004.
And the dates of receipt of claim, forwarding, all these are different.
These are
Those are not reflected in page
this is
68.
only for
no,
one
no,
quarter.
in 38, it is
This is
mentioned on
only for
21/11/2005. Received on 21/11/2005.
No, page 38.
But
Just
page
concentrate. It is a claim for 1/10/2004 to
12/2004, which was
Four.
received on 21/12/2005.
21,
12,
11,
11/2005.
11.
It's for only one quarter.
Okay. And this is to be submitted, the claim is to be submitted before what? District Industries and
My-
Commerce Center.
My lord.
Okay.
And they have to verify and forward. it
This
to
is
the-
one which was rejected on 25/3/2008.
My lord, they have said that this is the explanation was called for,
Explanation was called for.
my lord,
That is one. Then the periods in page 68,
my lord,
those are different.
my lord. In my reply, in fact, I've given the details,
Now, let me understand from page 60.
my lord.
What is relevant? DICC is relevant.
My DICC rating, even,
But Lordship, DICC is only the authority wherein the application will be filed with certain documents and all. So and DICC will forward this to state level committee. And state level committee is the only authority which can approve it. So state level committee, before approving it, they do their own homework.
My
They'll
lord,
have to look into those, all these things, whether the
No, no,
documents
just-
are there, is not there, or because
I want to-
ultimately state level committee has to approve.
I want to know that claim is to be filed before which authority?
Before the
DICC, yes,
DICC.
yes,
Because they cannot reach the SLC level directly.
No,
DICC,
So it is the basic, the starting point is DICC.
DICC.
and
Absolutely.
So that
Place-
the date of submission of claim at the DICC is to be counted.
Absolutely, absolutely, absolutely.
So that period, time barred or not, these are to be counted from the date of the period of claim vis-a-vis the date of submission of a claim.
Yes.
And suppose in between the date of submission of claim and the date of receipt of the claim at the SLC level, there may be a time gap.
There may be time.
Now, question is, suppose it is an incomplete claim, then there could be a different thing.
Correct.
And if it is a complete claim,
Then
there
of
could
course.
be different thing.
Yeah, different.
Now, you have taken the plea in the SLC meeting that due to non-submission, do you have any record that you have asked the party to submit those documents?
Nothing on record here. Lordship.
Then,
I can't say
reply
anything.
to
Then-
reply to it specifically said that no information was called for ever. Whatever claims were there, that was,
that is your categorical
yes,
statement.
in reply to your lordship, we have stated
Now-
specifically.
No, only thing is Lordship, now, I agree, Lordship, because there was, I have gone through the record, there was nothing I could find, because they said that they keep on orally informing them, because they always talk on over the phone and all these things. Those things are Lordship, I
Authorities
understand.
like this cannot do.
No, I understand that.
Now, only thing is that Lordship, what has happened, this matter was placed before the SLC again. So that again on 2014. So earlier also, Lordship, what has happened, because in my affidavit, Lordship, I have filed a document. So that basically gives a,
But nothing happened.
yeah, no, that only says that like
Nothing happened.
in no circumstances, you don't take any claim after 1 year of that the expenses are incurred.
But who is at fault? Question is, who is at fault, right? You have taken SLC meeting, recorded an observation
I agree.
that due to non-submission of, otherwise claim was submitted on time. Then they
Then
take another one.
Then plea was
That
taken.
non-submission of document so and so.
Correct.
Now, is it a statement based on records or is it a mere specious plea?
The statement on, I mean, statement has been made on the basis of the SLC, but
SLC made some observation
SLC minutes.
and
but-
SLC made the observation based on the statement given by commissioner or DICC.
That is your
But
knowledge.
DICC, they have made a categorical
Yes,
statement that we don't receive any queries from.
No, I agree, Lordship. And like Lordship, I'll have to be fair with your Lordship that I have seen the records. There was no communication I could find which was written. That I'll have to say, Lordship. But only thing is that now Lordship will observe that like this, since it was time barred, the state government is helpless. So state government has written to the DIPP because it's a sponsoring authority is the DIPP, Lordship. There is central government. So from central government, they haven't received any kind of response.
Who is
So that
CGC?
the problem. CGC is
CGC.
not there.
Better he be present. We can then,
So if the central government permits it, central SSC doesn't have any problem. That is the
no,
instruction.
we can hold that this is that claim was within time. The respondents are to process.
Yeah, that I leave it to Lordship because
The respondents are to process the claim of the petitioner on the basis, on the premise that the claim was in time.
In this case also.
that I cannot dispute because Lordship, what is there on
What I
record,
did.
I cannot.
That you'll also see para 21 of the judgment below.
That I am not sure because this is kind of mandamus that is
You know,
not,
as may be eligible.
they have to examine.
You know, it say your lordship saying.
They can take forward, they can process. That is what I am saying.
Petitioner as may be found to be due.
Same thing.
So as per found
so-
to be due. But otherwise.
They will process and bring it to its logic and conclusion in terms of the scheme.
You know, if the. Except you may-
Holding that the claim submitted by the petitioner is in time.
You know, if in case it is found to be due and if the direction not issued, then it will again 5-6 years. If it is
No,
found to be-
time frame.
If it is found to be.
There
due,
has to be a time frame.
but if it is found to be due, then the amount will be disbursed. And the statements made by the respondents are on the basis of knowledge in the affidavit. And I in the affidavit reply, I have specifically stated, my lord, that no such information was ever called for. You'll also see my reply, my lord. At page 5. Page 5 in the middle, my lord. Paragraph number 10.
What is the role of the state level committee ascribed in the scheme?
The state level committee recognizes and my lord recommends,
This is the scheme, right?
my lord.
They have taken a specific plea, Lordship, that page 8, Lordship, they have taken a specific plea, that's no doubt about this.
Huh?
That is, but they have taken a specific plea saying that they were not communicated as far as like if there is some shortfall of documents. They have taken specific,
That no information was ever called for.
they have taken specific.
And I also given a chart, my lord, you'll also find about the claims and when it was placed before the state level committee.
That will be available in the papers.
Now, Lordship, like in similar kind of situations, Lordship, what happens is that if, I mean, everything is fine, then state government can process this. They can place it before the SLC. Only one approval will be required from the central government. That Lordship may kindly direct it, that like if state government needs an approval, then they will take the approval. And that
No,
will
no
be placed before
approval,
the
what
SLC.
approval from the central government once your lordship, the judgment is there that needs to be treated in time. Then they have to protest it and
Process and
Yeah, for
give it
holding
finality.
my lord,
No, for holding the SLC, because SLC now this scheme is no longer there. So holding an SLC, they will need some approval. So that is what I am saying, Lordship, nothing else. That has to be understood.
But that is at an administrative level
Correct, correct. That's what Lordship I am saying, nothing else.
because clock has to go back to that time.
Because-
Yes, Mr. Chaudhary.
Because it's
Dev
a,
Chaudhary. You might not be aware of the facts. Basically, transport subsidy.
Lordship, no, since Lordship has fallen from your Lordship, the scheme is no longer there. Now, if it has to be relegated to that point of time, I think so, Lordship, because it has to be funded by the central government, Lordship. So some approval will be. Because it has to go back in time.
But it would relate back to that time.
It will relate, that is what I was trying to say, Lordship. It will relate back to
Doctrine of relation back. We'll go to
Now-
that time.
So if we have to go back to that time, since the scheme is.
Whatever
already-
arrangement you have to make, you have to make.
No, that has to come from the state government. That has to
Whatever
come from the state
process.
government.
The respondent are required to take, undertake the
Yes,
otherwise you not,
process, the claim of the petition, they have to take.
if the scheme is withdrawn and earlier claims are there, they will all go otherwise.
You talk. Page 38 was of 2012
My lord.
and this meeting is of 2009.
Well, that was for subsequent periods.
This, when did you get this SLC report? Because
No,
you filed this petition in 2014.
Well, I applied for that through ITI and then only I got it, I mentioned it,
Okay.
Lordship, there was one more SLC happened where this matter was placed again in 2014. That is there in my affidavit.
Paragraph?
Paragraph number 12 of the petition,
No, that's SLC.
That's a letter, Lordship, that's a letter written.
that we received on 15/5/2012.
I'm sorry, that is a letter written to the Secretary of Government of India.
No, the minutes of the meeting.
The minutes is there, but
Minutes were,
in my affidavit, we have stated about the SLC and written to the Government of India, stating that like, we should be permitted. So that letter is there in my affidavit. That's what I'm quoting.
And no affidavit by central government.
No, central government.
Lordship permits, Lordship, respondent number 5, Lordship, we have filed our affidavit, we are only on module agent, Lordship. If the funds being allocated to us, we will disburse them.
they have to only disburse the amount, nothing.
Now, Mr. Kolita,
Lordship.
in your annexer two,
Two, Lordship, that's what I was pointing.
right? Is there any basis for making this statement for non-receipt of various important documents from the units in time?
That is what Lordship I see.
No,
I
no
submitted
records.
records, Lordship, there was no communication as such has been given to them.
And this is verified on the basis of
But
knowledge.
because everything has been discarded on the basis of this statement, But
That is what Lordship.
there is nothing to back.
Written communication, there was nothing. They only said.
Oral, the authorities dealing with
I know it.
claims running into crores cannot
Yeah,
make
absolutely.
oral statements.
Absolutely, absolutely. Just too careless on their part. Too careless on-
And that too on the basis of knowledge, my lord.
The petitioner, the writ petition. Sorry, the petitioners. By this writ petition. Instituted under Article 226 of the Constitution of India, comma. The petitioners have raised a grievance that despite being eligible to receive subsidy under
My lord, if you,
the transport
if you also permit me some other matter, my lord. My lord,
subsidy scheme, comma 1971. They have been unjustly denied from receiving the same. Full stop. The petition number 1 is a company incorporated under the provisions of the Companies Act 1956, with its registered office at Kolkata, West Bengal. And the petition number 2 is a general manager, yes, commercial, of the petition number 1 company. It is stated that the petition number 1 company is a company who deals in fast moving consumer goods within bracket FMCG, and is engaged in manufacture of Ayurvedic medicines and cosmetics under the brand name Himani, Imami and Jandu. Full stop. The petitioner number 1, petition number 1 company within bracket hereinafter referred to as the petitioner company. For easy reference. Petition number 1 comment, also bracket has total 7 manufacturing units all over India, with 2 such units in the state of Assam, within Assam, at Amingaon and Abhoypur. The petition company has preferred the instant petition in respect of its claim arising out of the manufacturing, arising out of its manufacturing unit situated at, what is the full form of EPIP? Export Promotion Industrial Park.
Yeah.
Within bracket EPIP from Amingaon, Guwahati District, Kamrup, Metro Assam. It is the case of the petitioner that attracted by the incentives provided under the provisions of the Transport Subsidy Scheme, 1971, and the Industrial Policy Resolution Transport Subsidy Scheme framed by the Government of India. It is the Government of India. Government of India. And the Industrial Policy Resolution of 1997, published by the state government, by the Government of Assam, the petitioner company had set up a manufacturing unit at the EPIP, Amingaon. In and around the year 2003.
Commercial production commenced in 2003, Your Lordship.
Yes, because
So in and around 2003, when the
27 night.
commercial production,
Commercial production.
when the Transport Subsidy Scheme 1971 was in vogue. To stop. The commercial production from the manufacturing unit of the petitioner company, manufacturing unit situated at the EPIP, Amingaon, of the petitioner company commenced from 27/9/2003. So stop. The petitioner company got its manufacturing unit at the EPIP, Amingaon, registered with the District Industries Roman N Commerce Center within bracket DI Roman N CC Kamrup. Under the Transport Subsidy Scheme 1971. And state registration was affected by the DICC Kamrup. On and from 33/2004. Wide registration certificate number DICC stroke K-ES stroke 2003-2004 stroke 305 is 34%. Check for the or para 9 or so. As per the state registration, as per the registration certificate dated 33/2004 from the items of production from the petitioner company's manufacturing unit at the EPIP were Ayurvedic antiseptic creams, 1, 2, medicated oil, and 3, shampoo. Full stop. Finding itself eligible to claim subsidy under the Transport Subsidy Scheme 1971. The petitioner company submitted a claim application, submitted an application claiming transport subsidy before the General Manager DICC Kamrup on 28/9/2006, wherein the petitioner company made the claim for transport subsidy for the period from 1/10/2004 to 31/12/2004. So stop. Please check the dates.
Yes.
Check the dates.
Yes.
In the subsequent period, the petitioner company submitted applications claiming transport subsidy for different periods, for different quarters, right? Quarters, including the quarters. Come to page 38, huh? Page 60. Page 68 or one from 1/10/2006 to 31/12/2006, colon, Roman 2, 1/1/2007 to 31/3/2007, colon, 3, 1/4 from 1/4/2004 to 36/2004, colon, and 4 from 1/7/2004 to 30/09/2004. Full stop. Though the petitioner company had submitted applications for transport subsidy in respect of different quarters, comma, the such claim are not necessary to be referred to as the claims for those periods had been approved by the respondent authorities. I think 49. Case 49.
Please for me.
These were approved.
Yes, yes. Yes, sir.
So we are for 5 quarters.
Only these quarters.
In respect of the 4 quarterly periods, comma, mentioned above, comma, the petitioner company's claims were rejected by the state level committee in its 37th meeting held on 30/3/2009. Full stop. So far as the petitioner company's claim for the quarterly period, colon, 1/10/2004 to 30/12/2004, comma, the said claim was rejected by the state level committee in its meeting held on 25/3/2008. Right?
Yes, correct.
Aggrieved by such rejections of its claims, comma, the petitioner company has approached this court contending that its claims for the aforementioned 5 quarterly periods had been unjustly rejected by the respondent authorities. Full stop. I have heard Dr. A. Sharaf, learned senior counsel assisted by Mr. P.K. Bora, N.N. Borua,
And Dr.
Dr. Learned counsel for the petitioner, colon, Mr. R.K. Dev Chaudhary, Learned Deputy Solicitor General of India for the respondent number 1, semicolon, Mr. A. Kurita, Learned Standing Counsel, Industry and Commerce Department for the respondent number 2, 3, 4, and Mr. A. Das, G. Das, Learned Standing Counsel,
Only council.
Learned Counsel for the respondent number 5. Post. Dr. Saraf Lana, Senior Counsel for the petition, has submitted that as per the transport subsidy scheme, comma, a claim for transport subsidy is to be made for a quarterly period. And such claim was to be submitted within a period of 1 year or 2 years.
1 year, 1 year. of
1 year.
incurring Expenses,
Uh-huh.
1 year of incurring expenses. That
1
notification.
year from
Yes.
the date,
From the date of incurring expenses.
where from the exact phrase?
Page 68, your lordship, it's written 2 years.
68.
Specified time of 2 years.
Lordship, there is some confusion there. Because if Lordship finds 68, 368. 60 years, it is mentioned as 2 years.
Yes.
But Lordship, that Government of India notification, that is at in my affidavit, page 13. A, the original one is there. Last to the bottom paragraph, the last line, Lordship. It's 1 year from the date of incurring expenditure.
Okay, from the date of within a stipulated time period. From the date of incurring the expenditure. Full stop. He has contended that the claims for transport subsidy in respect of the 5 quarterly periods, comma, referred above, comma, were filed within the stipulated period before the General Manager DICC Kamrup. Full stop. But by drawing attention, he has drawn attention to the letter to a letter dated 38 letter bearing number 38 dated 17/3/2012 of the Commissioner of Industries and Commerce, Assam. Full stop. In that letter, comma, drawn attention to the contents of a letter, bearing number so and so of the Commissioner of Industries, wherein the Commissionerate had observed that the claim for transport subsidy of the petitioner company for the period from 1/10/2004 to 31/12/2004 was rejected by the state level committee on the ground that there was a gap of, there was a delay of More than 1 year. No, there was a gap of more than 1 year. In receiving the claim, at the level of the state level committee. Full stop. He has also drawn attention of the minutes of the state level committee. Minutes of the meeting of the state level committee, comma, held on 39/2009, comma, wherein the claims for transport subsidy for the other 4 quarterly periods were rejected by the state level committee on the ground that the claims could not be placed before the state level committee within a specified time period of 2 years from the date of incurring expenditure. Full stop. It is his contention that from the letter dated 17/3/2012 of the Commissioner of Industry and Commerce, Assam, as well as from the minutes of the meeting of the state level committee held on 30/3/2009, it is evidently clear that the claims for transport subsidy for all the 5 quarterly periods were received at the office of the General Manager DICC Kamrup within time, notwithstanding the confusion created by the respondent authorities as regards the time limit of 1 year or 2 years from the date of incurring the expenditure. Anything? Anything?
And the central government notification, it should not be more than 1 year.
That is why I have said notwithstanding the confusion created by the about the time limit. Both observed within time.
It should be 1 year, but they have mentioned as 2 years.
I don't know. That is why I have said. Both observed within time. Both 37 and 67. Page 38 as well as page 39 says within time. 1 year or 2 year, both have observed.
Then Lordship, but this 38 page, Lordship has mentioned 38 page 38. That claim was of different period. That Lordship has already.
I have said 5 periods, total 5 periods.
But this was a different period, and like the SLC was also a different date. That Lordship has already pointed out.
I have said SLC minus 4 plus 38 page 1, 4 plus 1, 5. Mr. Dev Churil and Deputy Solicitor General of India has submitted that the claims for transport subsidy of the petitioner company was rejected by the respondent authorities at the state level. Pushpa. You don't have any instruction perhaps regarding this 93 annexure 2 letter? I don't,
No, Lordship, we are not.
from the central government.
Nothing has come, that's what I.
No, in fact, I had taken it up, nothing else.
You have no instruction.
Because I had taken it up in the month of February now.
As regards the proposal forwarded from the end of the Commissioner of Industries and Commerce from Assam, white letter number so and so, page 93, dated 23/2014, for consideration of the alleged time-barred transport subsidy claims of 6 industrial units, including that of the petitioner company, various claim period is concerned. He has submitted that he has not received any instruction, further instruction in the matter. Post of Mr. Kara, Mr. Polita, Standing Council, Industries and Commerce Department, has submitted that. So far, the claim application for transport subsidy for the period from 1/10/2004 to 31/12/2004 was received at the office of the Deputy, General Manager DICC on 28/9/2006. Full stop. The other claims, other 4 claims for transport subsidy from the petitioner company were received on 15/6/2007, 26/7/2007. Oh. 15/6/2007, no, the capital Kirigo. ABCD আছিল ন আপুনি দিব the other 4 things for transport subsidy for the water colon 14/2004 to 36/2004 colon quarter 17/2004 to 39/2004 colon 110/2006 to 31/12/2006 and quarter 11/2007 to 31/3/2007 were received at the office of the General Manager DICC on 13/5/2005, 13/5/2005, 15/6/2007, and 26/7/2007. After receipt of the claim applications on such dates, the applications were processed and thereafter forwarded to the Commissioner, Office of the Commissioner of Industries and Commerce, Assam, who, after processing, had, in turn, placed the matter before the state level committee for consideration, right? Dates are correct? Full stop. It was after raising of the claims before the state by the Commissioner of Industry and so before the SLC, the state level committee considered the claims and rejected the claims on the ground that the same were found to be placed before it beyond the specified time limit from the date of incurring the expenditure. Will resume. Mr. Das. No?
Production list item number 1 for withdrawal.
Mr. Das, learned counsel for the respondent number 5.
Number 3.
Has submitted that the rule of respondent number 5 is that of a designated nodal agency appointed by the Government of India for the purpose of disbursement of transport subsidy, amongst others, in accordance with the guidelines issued by the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of Assam, Government of India. Its responsibility is limited to receipt of claims from the units and to process them. After computation of the subsidy amount found eligible by the applicant unit, it finally recommends the same for disbursement. No. Okay. The responsibility of admitting claims from the applicant units and processing them and computation of subsidy amounts and finally recommending the same for disbursement rests with the concerned state government. Once a claim for transport subsidy is approved by the state level committee, the particulars of the claim are forwarded to the respondent number 5 by the member secretary of the state level committee of the state government. So after adhering to the procedure laid down by the scheme, it takes necessary steps for disbursement of the fund to the applicant unit. But he has submitted that insofar as the rejection of the claims of the petitioner company is concerned, it had no role in the decision-making process, right? That is all. I have considered the submissions of the learned counsel for the parties and have perused the matters brought from the court by the parties through their pleadings. I have also gone through the decision placed by the learned senior counsel for the petitioner. The decision of this court in Ishwar Food Products Private Limited versus Union of Indian Errors, reported in 2013, 1 JLR 359, placed by the learned senior counsel for the petition. Before deliberation on the respective contentions advanced by the learned counsel for the parties, it appears necessary to have an overview of the transport subsidy scheme 1971 framed by the Government of India and published by the notification dated 23/7/1971. By the from the notification, Supra, it is noticed that the transport subsidy scheme was brought into effect on and from 23/7/1971. And the same was made applicable to all industrial units within bracket barring plantations, refineries and power generating units is 24 of the silo bracket close, both in the public and the private sectors, irrespective of their size in the selected areas within bracket capital A, within bracket capital B, within bracket capital C, and within bracket capital D for a period of 5 years from the date of commencement of commercial production. That's all. It is submitted to the bar that the tenure of the scheme was extended from time to time.
Yes, yes, come to.
The tenure of the transport subsidy scheme 1971 was extended from time to time, and it is not in dispute that at the time of submission of the claims for transport subsidy by the petitioner company, the transport subsidy scheme was in currency, was involved. EOZUE. Full stop. As per definition provided in clause 4 within brackets small a, comma, quote unquote industrial unit means, huh? And full stop. Double लिखी थी वो, huh? Double लिखी थी, page 24. As per clause B, comma, quote unquote, new industrial unit means लिखी थी. In clause 6 of the scheme, comma, the details were provided. Full stop. Details of the scheme was provided. Full stop. A transport subsidy was to be given to the industrial units located in the selected areas in respect of raw materials which were brought into and finished goods which were taken out of such areas. Full stop. In the case of it took 26 of Roman 4 plus, na? Roman 4, small 4. In Assam, this is 26, page 26, Roman 4. আর দুটো অ্যাস্টারিক্স থাকা হেতু হেতু খালি পাস্ট টেন্স করে দিব, পাস্ট টেন্স করে দিব। The transport subsidy scheme has further provided that the Northeast Development Finance Corporation within bracket NETFI shall within bracket the respondent of type shall act as a nodal agency for release of transport subsidy on the basis of the recommendations of the state level committee, comma, for the Northeastern region, comma, as per the existing terms and conditions of the scheme. Page 28, B test. Of the 27 of April. The state government had the responsibility to set up a committee consisting of the Director of Industries, comma, a representative each, page 27, Roman 12. Page 27, that is the role of the state level committee,
Correct, correct.
Roman 12.
Yes, Roman 12.
In the correct. That's- The petitioner company from the registration certificate issued by the General Manager DICC Kamrup on
15/6/2004.
date.
Page 24.
33/2004,
Lecture B.
comma, the petitioner company commenced its commercial production from its manufacturing unit located in the EPIP Amingaon on and from 27/9/2003. Full stop. The petition company has submitted its claims for quarterly its claims for transport subsidy under the scheme quarterly for a number of quarters. Full stop. From the minutes of the meeting of the 37 meeting of the state level committee, comma, held on 33/2009, comma, it transpires that the petitioner's claim for transport subsidy was approved by the state level committee for 3 quarters. That is 1, from 1/4/2007 to 36/2007 to from 1/7/2007 to 39/2007 and 3/11/2008 to 31/3/2008. For different amounts, for different subsidy amounts, transport subsidy. It is the claims for transport subsidy for 5 quarters, that is 1, 2, 3, 4, 5, which have been rejected by the respondent, by the state level committee. Against which the petitioner company has approached this court. Full stop. While one of such claim was rejected by the state level committee in its meeting held on 25/3/2008, the other 4 claims were rejected by the state level committee in its meeting held on 30/3/2009. Full stop. Insofar as the reason assigned for rejecting the claim of the petitioner company for the quarter colon 1/10/2004 to 31/12/2004 was concerned, it was noted that in the letter dated 17/3/2012 Sutra, that the claim application from the petitioner company was received at the end of the General Manager DICC on 28/9/2006. And thereafter, the state claim was received at the end of the Commissioner of Industries and Commerce, Assam on 5/10/2006. 5/10/2006. Full stop. No. The claim of the so was received on 21/11/2005. Received. And the office of the General Manager DICC Kamrup forwarded the claim to the Commissioner of Industries and Commerce, Assam on 28/9/2006, and the same was received by the Commissionerate on 5/10/2006. Full stop. The claim proposal was placed before the state level committee in its meeting held on 25/3/2008. Full stop. The claim for the quarter 1/7/2004 to 39/2004 was received at the office of the DICC, General Manager DICC Kamrup on 13/5/2005. Commissioner has become director or what later on?
It has become director, then it has become commissioner. Now it's commissioner.
Okay. And the said claim was received at the commissionerate level on 11/12/2006. Full stop. For the quarter, for the, in respect of the claim for the quarter 1/4/2004 to 36/2004, comma, the petitioner company submitted its claim application on 13/5/2005 at the office of the General Manager DICC Kamrup on, and the said claim was received at the Commissioner Office on 19/2006. Full stop. In respect of the claim for the quarter 1/10/2006. Serial করে দিব, huh? To 31/12/2006, comma, the petition company submitted its claim at the office of the General Manager DICC Kamrup on 15/6/2007, and the office of the DICC and the same was received at the commissionerate level on 3/12/2006. Full stop.
2007 or not?
2007.
7.
Seven. Full stop. In respect to the claim for the quarter 1/1/2007 to 31/7/2007, comma, the office of the DICC General Manager DICC Kamrup received the same on 26/7/2007, and on being forwarded, comma, the said claim was received at the commissionerate level on 3/12/2007. A bare perusal of the a perusal of the above noted incidents go to show that the claims by the petitioner company for a respective quarter was submitted at the office of the General Manager DICC Kamrup within a period of 1 year, correct? 1 year?
1 year.
1 year from the purported date of incurring the expenditure. Full stop. For better appreciation, the relevant excerpts from the minutes of the meeting, 37th meeting of the state level committee, which contain the region for rejection of the claim for transport subsidy made by the petitioner are was reflected are quoted are extracted. Here in below, page 60, B2B. B2B, page 60. From the above excerpts from the minutes of the meeting of the state level committee, it has clearly emerged that the claims for transport subsidy in respect of the aforementioned 4 quarters were received at the office of the general manager DICC within specified time limit. Full stop. The state level committee had, however, observed that due to non-submission of some important documents and clarification on certain matters, the claims for transport subsidy of the petitioner could not be placed before the state level committee within the specified time limit of 2 years from the date of incurring the expenditure. It was after assigning such region, the state level committee advised the member secretary to take up the matter with the, it was directed to taken up.
Yes, it was directed to taken up with the DIPP. So
What is DIPP?
you see,
DIPP is, I think, DIPP, this DIPP. With the Department of Industrial Policy and Promotion, within bracket DIPP, Ministry of Commerce and Industry, Government of India. Full stop. What happened thereafter?
So they wrote a letter, so that is there.
That letter
Yes. that-
in your affidavit of opposition.
Yes.
So it took 5 years. 5 years.
Then after it also, like, off record, there was no follow-up, nothing.
It was after. How industry will be promoted? Rightly or wrongly, they have made some claim. At least they deserve consideration.
Absolutely no, sir.
Allow approval or rejection, but is this the way to promote industry?
In respect of.
I'm not asking you. I'm not asking.
A different.
Huh?
It was noted that it is submitted within a period of 1 year. Can it be within a stipulated time? Because in respect of the second quarter, the claim was submitted after 1 year.
Save and accept.
In respect of the second quarter, your lordship.
Page.
Page 68, period B.
Huh?
Page 68,
Which one is beyond 1 year? Tell me.
period B.
Huh?
Period B.
Okay, save and accept.
1/1/2007 to 31/3/2007.
They are recording specified time limit. Why should I? They are experts sitting there with an aim to consider it expeditiously. So many of expeditiousness is apparent from this letter of 2014. Right.
No, basically, they are taking the date of SLP. That is the mistake they have done.
I have quoted everything.
Yes.
I have quoted the entire portion.
Yes. That's why that is the, I mean, as far as.
Let them apply their mind. I have quoted this portion.
Yes.
this minutes, page 68, relating to Messrs Imami, I have quoted this portion in the order. Let them apply there, ma'am. It was after lapse of in and around 4 years, 5 years, comma, the Commissioner of Industries and Commerce, Assam, write his letter bearing number, page 93, dated 23/2014, comma, forwarded the matter to the Department of Industrial Policy and Promotion, comma, Ministry of Commerce and Industry, comma, Government of Assam, India, for consideration of the alleged time barred subsidy claim of the petitioner company, along with 5 other similarly 5 other alleged time barred claim. Full stop. While forwarding the proposal for consideration, comma, the Commissioner of Industries and Commerce, comma, Assam, observed that the claims became time barred for non-receipt of various important documents from the units in time, comma, which ground was also found mentioned in the minutes of the 37th meeting of the state level committee held on 33/2009. Full stop. Insofar as the claim of the petitioner company is concerned, comma, the letter dated 23/2014, heading to divorce, page 93, pardon, C to C, C to C, D to D. From the observations made in the minutes of the 37 meeting of the state level committee held on 33/2009, and the contents of the letter dated so-and-so of the Commissioner of Industries and Commerce, Assam, comma, the issue that has arisen, the issue that requires a consideration is whether there was any lapse on the part of the petitioner company in making the claims for transport subsidy under the Transport Subsidy Scheme 1971. Full stop. The minutes of the 37 meeting of the state level committee had observed that the claims were submitted, the original claims were submitted by the petitioner company within the specified time limit at the office of the DICC. Full stop. The reason for not processing the reason assigned for not processing the claim of the claim for transport subsidy was non-submission of some important documents and clarifications on certain matters. Reason assigned in the minutes of the meeting. Full stop. In the letter dated 23/2014, it was mentioned that the claims for transport subsidy could not be placed before the state level committee in time due to delay in processing of the claims at the district level as well as at the commissionerate level, quote unquote, for non-receipt of various important documents from the units in time, unquote. Good story. The letter of the Commissioner, Industries and Commerce, Assam, dated 23/2014, had, however, admitted that the petitioner company had submitted their claims well within the specified time period in the office of the District Commerce, District Industries, DICC. Full stop. In respect of the petitioner has categorically asserted that at no point of time, the petitioner company was informed as regards deficit of the requisite papers along with the claim applications. Full stop. The petitioner company has categorically asserted that they were kept in complete dark for a substantial period of time about the reasons for rejection of the transport subsidy claims until the petitioner company obtained the minutes of the 37 meeting of the state level committee through an application under the Right to Information Act, 2015 in the year. Which year you got it? 15/5/2012. 15/5/2012. Full stop. The respondent authorities comma, more particularly, comma, the district industries and commerce, general manager, district industries and commerce, Kamrup, as well as, and the commissioner of industries and commerce, Assam, have maintained complete silence as to whether they had asked for any documents from the petitioner company with the information that their claim applications, comma, under process at their ends on the dates mentioned herein above, comma, were deficient of any documents. On further perusal of the region assigned by the state level committee in its minutes of the meeting showing so, as well as the commissioner, letter of the commissioner goes to indicate that the delay in processing the claim applications of the petitioner company had occurred at the ends of the at the district level as well as at the commissionerate level, which ultimately resulted in delay, which ultimately resulted in delayed placement of the proposals of the claims of the claim proposal of the petitioner for transport subsidy at the before the state level committee. Full stop. It is evident that once a claim application is filed by an applicant for transport subsidy under the transport subsidy scheme 1971, such claim is to be processed at 3 levels. First at the district level, secondly at the commissioner level, and finally at the level of the state level committee. Full stop. Para. From the scheme of the from the the transport from the notification dated 23/7/1971, whereby the transport subsidy scheme, 1971, was notified, it is evident that the government of India had framed a scheme for grant of subsidy on the transport of raw materials and finished goods to and from certain selected areas with a view to promoting growth of industries there. Full stop. The benefits sought to be given to the industrial units, new industrial units set up in the north eastern region, including Assam, under the scheme was more than the ones given to the other regions of the country. Full stop. For example, the transport subsidy in the northeastern region covered interstate movement, whereas such subsidy was not available in respect of the developed part in the developed states. Full stop. Thus, it is evident that the thus it is evident that better benefits were made available to the industrial units, new industrial units set up in the north region, including in the state of Assam, for a faster industrial development, as admittedly, the north region was industrially backward than many other states of India. Full stop. When it is from the facts and circumstances of the case in hand, it has become evident that the delay there was no delay in submission of the claims for subsidy. There was no delay on the part of the petitioner company in submission of their quarterly claims for transport subsidy for different quarters. And full stop. The delay which had occurred were clearly attributable to the to the office of the DICC, Kamrup, and the office of the Commissioner of Industries and Commerce, Assam, in processing the such claims, and thereafter, to forward the same to the next authority involved in the process of examining the claims. Full stop. The delay that had occurred at their level had ultimately resulted into delayed placement before the state level committee, which was the final authority to examine the claims and to recommend disbursement if the claims are found, if the claims are eligible under the Transport Subsidy Scheme 1971. Full stop. In such view of the matter, the region assigned in the minutes of the 37 meeting of the state level committee held on 33/2009, and in the letter of the Commissioner of Industries and Assam Industries and Commerce, Assam, dated 23/2014, are found to be spacious and without any basis. Full stop. By assigning such region, spacious region, the authorities have sought to shift the fault to the petitioner company, which is found unsustainable after perusal of the materials on record. Full stop. There is nothing the safety is found safely advanced by the state respondent authorities, concerned respondent authorities, in rejecting the claims of the petitioner was not on the basis of any materials on record. To stop in such to stop. That is at this stage. It is also appropriate to refer to the observations made by it would refer to in Isharpur Products Supra, the claims for transport subsidy of the petitioner therein under the Transport Subsidy Scheme 1971 was rejected on the ground that the claim was made in a consolidated form and submitted after more than 1 year period, right? 1 year period.
Yes, 1 year period.
In such backdrop, the court had observed as under 16, 17, 18, and 19. Para. The facts and circumstances obtaining in the case in hand is quite similar to the facts and circumstances of the case in Isar Food Product Limited Supra. Full stop. A genuine claim, a genuine claim. The court is of the considered view that a genuine claim of an applicant for transport subsidy and the transport subsidy scheme should not be rejected on the with a ground which is not attributable to the applicant. Full stop. As the transport subsidy scheme was framed for the purpose of giving incentives to incentives in setting up industrial units in the lesser developed regions like the North region, the respondent authorities are duty bound to adopt a reasonable and liberal approach in processing the claim of such applicant. So in such view of the matter, this court is of the view that the claim of the petitioner for the aforementioned claim of the petitioner for transport subsidy under the transport subsidy scheme 1971 for the aforementioned 5 periods deserves reconsideration at the end of the respondent authorities. To stop accordingly, the writ petition is therefore is disposed of, directing the respondent authorities more on the more particularly, the respondent number 2 to 5, 2 to 4, 2 to 4.
Yes.
2 to 4. To process to process the claim of the petitioner strictly in terms of the provisions contained in the transport subsidy scheme 1971 in an expeditious manner. Without expeditious manner. And if after processing the claims of the petitioner, the amounts found entitled to the petitioner company shall the matter regarding the file shall be decided and thereafter, take necessary steps for its disbursement in consultation with the respondent number, in consultation with the Department of DIIT, Ministry of So and so, Government of India. Considering the events, preceding events, and taking into account the object and purport of the transport subsidy scheme, it is observed that the entire process shall be completed within a period of
3 months minimum.
4 months. I'm giving 4 months.
4 months.
From the
Apply
date
for
of
4 months.
receipt of a certified copy by the respondent authorities. From the date of receipt of a certified copy of this order at the office of the respondent number 3.
Gotcha.
Let DICC go out of the process. The commissioner should step in. Anything? No.
Or directly, Lordship, or commission, respiratory, yes, Lordship.
Commissioner,
Correct.
if requires some correction, I will make the correction. Anything to be added? Single judgment. With the aforesaid, with the observations made and directions given above, the repetition stands allowed to the extent indicated. There shall, however, be no cost order as to cost.
Oblige.
Production list item number 1 for withdrawal.
After being listed, nobody is available. Who is Excise Council? Yeah.
Item number 6.
Furnish the judgment of the division bench.
Oh, yes, yes, Hey, I thought
Against the judgment, my lord.
what is the WA number? 186.
WA number 186 of 2023.
Common judgment.
Of 3 cases, common judgment.
Somehow it is misplaced. Yes, Mr.
Against the judgment, my lord, they have preferred an SLP, my lord.
SLP.
Yes,
There is no stay, my lord. Only notice has been issued.
What was the observation there?
In this case, my lord, in the writ appeal, my lord,
So earlier it was
there's another case which is pending.
we said delayed consideration because
Because
of
there's
the
another-
division bench judgment.
There's another division case which is pending.
Okay, private respondent has gone.
Yes, caveat was filed, we have entered appearance.
Oh, so you are also
No, I
represented.
was there in one of the cases, my lord, in the division bench.
Then it will be a multiplicity of judgments.
Yes, my lord.
But
It
there's
is
no,
not ultimately, when was the order of settlement?
settlement order was 2021.
See,
my
we
lord.
delayed the thing because there was a writ appeal pending before the division bench.
Yes, my lord.
I think this matter was with that particular notification, right?
Yes, yes.
2018, there is notification.
Ultimately, division bench had happened. What had
Division
observed?
bench judgment, my lord.
One
is
minute.
of-
Let me have a print out. Final order, date,
Date is, my lord, 16 June
16 June.
2023.
1 minute. More. না, খবর পাই। টেনশন করিস না।
Hello, I have a
You have a copy? It was there somehow misplaced.
My relevant paragraph is paragraph 68 onwards, Manu.
Let me have a better one.
Yes, my lord.
একটু সাইকেলে মারা।
They have to appear.
তোমার out of three, I would ask. এফেলে one is one. It appears, I think, from the earlier discussion, both were deficient.
Yes.
Both are deficient. I have to admit, my PAN card is not there, but they have not fulfilled certain
Now,
criteria.
what has been held by the division bench
That a
regarding
gazette
card?
notification has to be followed, Manu.
Huh?
It is supplementary in nature.
You go out,
Even they go out.
and whatever their deficiencies,
Their deficiencies, the fisherman experience certificate, then the distance certificate, then also the audited balance sheet. They had given only for 2 years, not for 3 years. And as per the judgment, my lord,
so they are also deficient.
they are also deficient.
They also go out.
They also go. out.
So that notification is to be followed
It is to be followed according to this division bench judgment.
in letter and spirit.
Yes, ma'am.
And on what ground the other side has gone to Supreme Court?
They are saying, my lord, that it is, they are relying upon a single judge judgment. They saying that it is only, it cannot be followed in strict sense of term, my lord. When the fishery rules are there, then it cannot be followed. You have to go by the fishery rules, but this judgment says that it is in supplementary to the fishery rules. It is to supplement the fishery rules.
To supplement the fishery rules. There lies another gray area which I did not touch because of that in my in a judgment rendered by
In
this
this
court.
series also, my lord has passed the
No, I did not touch that issue because that is a gray area.
Yes.
Unless that is covered, this litigation will continue. পারিছে না? পারিছে না? আচ্ছা। Because I mean, there is no issue for men notice. Here will. You are in that Supreme Court,
I am.
yes,
I am Dhornath.
you are,
I am Dhornath.
or which one? Dhornath.
Dhornath. I am the appellant in the division bench. madam.
You are appellant.
Appellant in 2 cases. There are 3
Appellant.
parties, madam. In this division bench case, there are 3 parties. Hirbil, Dhornath and Kosurola.
Hirbil,
Dhornath and Kosurola.
Hirbil was given the fishery.
In Dhornath was given the fishery.
Dhornath.
In this round, my lord. Earlier also there was 1 round, my lord. My lord had also dealt with in the earlier round, my lord.
Get confused with the names of. Sometimes this fishery society is petitioner. Sometimes the society is respondent in other case. Oh, which paragraph?
The relevant paragraphs are paragraph 68 onward, my lord.
60, 1
68,
68.
68. In the instant case,
One,
comma,
one. Hmm. In the instant case. In the order it had followed. Followed the provisions of a notification dated. And it is not that society which was bestowed upon the benefits of the said order seeks to impose the provisions thereof. Under the aforesaid principle that what would be impermissible is that if the authorities are not following the provisions of the notification, it would not be open for the tenderers. What is the meaning of this paragraph 68?
But 68 message, it says, my lord, that it is supplementary in nature, my lord. On reading of the provisions of the Assam Fishery Rules 19, may I read the entire paragraph?
68.
668, my lord. In the instant case, it is noticed that the notification dated.
What paragraph?
68, 68.
68.
I am reading from the SCC online version, my lord.
Oh.
68. my lord.
65 and 66 maybe there, sir. 65 and 66.
Okay, 65 है.
65 and 66.
Hmm. Okay, 65.
In the instant
Hmm.
case. In the instant case,
Yes.
it is noticed that the notification dated 18/1/18, even if it is referred as an executive instruction, provides for certain procedural requirements in carrying forward the tender process for settlement of fishery under the Assam Fishery Rules 1953. In a situation where a more detailed and necessary procedures have not been provided in the rule. On a reading of the provisions of the Assam Fishery Rules 1953 and a notification dated 18/1/18 in a conjoined manner, it is discernible that the notification dated 18/1/18 is supplementary in nature, providing for some more detailed and necessary procedures in carrying forward the tender process, rather it being an attempt to supplant the Assam Fishery Rules 1953 or to provide anything in conflict with the provisions of the rule. From such point of view, the proposition put forth by the respondent hereby that the provisions of notification dated 18/1/18 would be inapplicable, nor can it be relied upon for carrying forward the tender process would be unacceptable and hence rejected. It is an accepted proposition in administrative law that the provisions of statutory law can always be supplemented, though not supplanted, so as to provide for a more detailed and clear and unambiguous procedure for carrying forward a particular act. The further provisions in paragraph 42 of the impugned judgment that the provisions of the notification dated 18/1/18 shall not be enforceable in law would also have to be clarified that although the provisions of notification or executive instruction may not be enforceable, but at the same time, it has a binding effect on the authorities to follow the provisions thereof while carrying forward a particular act for which the notification or executive instruction may have been put in place. Instead, in the instant case, the settling authorities in the order dated so and so has followed the provisions of notification dated 18/1/18, and it is not the society which was bestowed upon the benefits of said order seeks to enforce the provisions thereof. Under the aforesaid principles, what would be impermissible is that if the authorities are not following the provisions of the notification, it would not be open for the renderers to seek for an enforcement of the provisions. But the reverse would not be applicable, that if the tendering authorities are following the provisions, the same warrants an interference on the principles of provisions of notification being not enforceable. In such view of the matter, we do not see any acceptable reasoning that the settling authority in the settlement order dated so and so, having followed the provisions of the notification dated 18/1/18, and interference would be justified on the principle that notification is merely in a nature of executive instruction and that it is not being framed under any statutory provisions. The provisions therefore cannot be relied upon by the settling authority. In view of the conclusions arrived that the Bakija clearance certificate of Dheer bill having not been submitted for the relevant period, which would result in essential requirement not being fulfilled, and that the call deposit submitted by Kosudola FCS being unacceptable, which would again result in essential requirement not being fulfilled. We uphold the order of settlement dated 24/3/22. Although in respect of the other reasoning contained in the said order, in respect of Dheer bill and Kosudola as indicated above, would be unacceptable. Accordingly, judgment and order is so and so. However, learned single is satisfied, my lord.
So it was, the settlement order was made in favor of Dheer bill. Yes.
It was passed in favor of,
Dheer bill by the single judge.
yes, in favor of Dheer bill. Settlement initially was given to Dhornar, but the single judge interfered and it was passed in favor of Dheer bill. Then we filed a writ appeal. Kosudola also filed a writ appeal. And the writ appeal of Dhornar was allowed, madam.
Yes, what do you say?
Yes, madam. Another writ appeal also been pending, madam.
Which one?
Writ appeal 88 of 23, that is pending, my lord. But this judgment has clarified the position.
Now,
On the same issue, madam.
same issue maybe, but if they have to defer, then it has to be forwarded to the full bench.
Yes, madam.
Now, it has been categorically held that if the authorities decide to follow the notification, then it is enforceable. So it is supplementary in nature, since it does not supplant any of the provisions of the Assam fishery rules. And it is not in conflict with the Assam fishery rules. Yes, ready,
Yes, fine.
ready? Okay, what are that? Show me now. I have forgotten.
Man, I had given a list of judgments, my lord, earlier.
You have given list of judgments, the number of judgments. Now, on the basis of this division bench judgment, we are, let us confine to,
The division bench judgment.
that is binding,
That is binding now.
that is binding on this court.
My lord, my senior AC Sabha is in court number 17, my lord. One is that.
Let us hear him first. You note down. I have forgotten the previous.
Record is also.
You have records.
I haven't been there.
First you say, let us see the settlement. No, first you take me
The
to the,
first, the
first you
NIT,
take me to the NIT.
NIT, my lord. NIT is at page 36, my lord.
36.
May I read, my lord?
%60?
60%.
Korkori mismo হবে।
48 number for করে মিট মধ্যে।
$78,000.
78,000 is the amount fixed.
Last date was extended? No.
The last date was NIT dated 9/2/2021.
Was it extended later on? No.
It was 19/2.
What is the date? 9/2.
19/2/2021.
No, and what was the date of the tender notice?
9 February 2021.
9.
My lord had earlier dictated a part of the order. One. The fact part. One.
Now let me refresh myself.
Yes, my lord.
Perhaps it was long back.
It was, my lord.
Maybe in May or June.
Indeed, for in the month of March, February, March.
March, it has gone out of the memory. Okay, this is the tender notice. Then,
Then
what
it-
is, how many bidders?
There were, my lord. 4 bidders.
4 bidders. Now, what are the documents required as per this tender?
But
We'll come
documents
to the
required,
notification later on.
documents required are at page 37, my lord. Or to, no,
Fishing. Baki je,
the vernacular is page 45.
45.
মাছ ধরা অভিজ্ঞতা প্রমাণপত্র।
মাছ ধরা জেলায় উত্তর করা বাকি যায়। মীন পালক, fishing, what is go? What does it call?
জিলা উপযুক্ত পৰা বাকিতে মুক্ত প্ৰদেশ
What does it call?
গজ অনুসূচিত জাতি মহিমাৰ সম্প্ৰদায়ৰ লোকৰ হোৱা প্ৰমাণপত্ৰ আৰু ভিত্তিত মাছমৰীয়া মীনপালক হোৱা প্ৰমাণপত্ৰ। 157.
100% SC fisherman,
Yes, my lord.
right?
Yes, my lord.
Koi is fishing experience.
Yes, my lord.
Koi is baki jai.
Yes, my lord.
3 is 100% SC fisherman.
Yes, my lord.
Okay. Postal order,
Then D is call deposit.
call deposit. Okay, call deposit. Then registration certificate.
Registration certificate.
Then PAN card
PAN card.
in the name of the society.
Society.
Then the authorized persons, photo and whatever.
Yes, my lord.
Then balance sheet
Balance sheet.
and profit and loss.
And
Labh Luksan, profit and
Labh
loss
Luksan, yes.
statement. Then neighborhood.
Neighborhood.
Okay. And what is the requirement as per the notification?
Notification is at page 51. Hundred percent.
On the earlier date, why we are not going, we did not go because this clause 1,
Yes, my lord.
right? It has been decided that the following clauses are to be included in the notice inviting tender for settlement. This was not included. Now division bench has said
It is to
now, but I am on the technical, unless it is brought to the knowledge of the bidder, it cannot be enforced. Anyway, now division bench has decided it. 100% actual fishermen from
Fishermen.
whom?
by the ARCS.
ARCS. Submission of 100% actual fishermen, fishery property issued by the as indicating to all the fishermen are actual fishermen belonging to the so and so. Okay, neighborhood certificate,
By the concerned revenue office.
revenue cycle officer. Clear indication of specific distance.
There was no specific distance.
Okay. Oh, no, we are not going to facts, we are just requirement, we are on to the requirement. Fisherman experience certificate
In
from DFDO.
India respondents, it was issued by the circle officer.
Oh, no, we are not.
Yes, yes. Requirements,
understand.
yes, yes. my lord.
Don't jump to the facts immediately. Baki jai. Okay, security,
Security is the call deposit.
small deposit. Placed in favor of the concerned BC.
Next is PAN card.
Society's registration, then PAN card. PAN card issued
In the name of.
by
the
income tax authority in the name of the Fisherman Cooperative Society NGO so and so, not individual PAN card in the name of the office bearer of the so and so. passport photograph, balance sheet and profit loss statement for consecutive preceding 3 years.
3 years.
Shall be submitted duly certified by the competent authority of Corporation Department in respect of cooperative society and by chartered accountant in respect of NGOs and SHGs. Documents to be submitted by DC forwarding featuring. This is made available where? Page 51.
This starts from page 50 of the Gazette notification.
Okay. Now, where is the settlement order?
Settlement order is at page 49.
Okay, which one is petitioner society?
We are Giacomo number 2.
Serial number, society of her so and so. Submitted all documents in terms of which the foundry will accept pen. Accept pen. Go. You are out.
Accept pen.
And what about
Them, my lord. Asirvad, they are Asirvad.
Asirvad?
Yes,
Serial number 1.
serial number 1.
Yes, all documents submitted with the tender are found to be in order. All the while. Let us see their defective document
Their effective documents
according to you.
we applied to RTI.
Ah.
Then, my lord, the documents which we had received. First is at page 60 is the fisherman experience certificate.
60.
60.
1 minute, 1 minute. Respond number?
Respondent number 7. 7.
What is page 60? What is there?
This is the fisherman experience certificate.
Fisherman. Page 60. As per the notification, it is to be from here.
The district fishery development officer.
Okay, but it is by circle officer.
Circle officer.
Yes, next.
Next is the Bakijai certificate at
Yes.
page 61.
Sure. What was the date of the tender notice?
19 to 21. 9th of February 21.
9th of February 21.
Yes, madam. After the Gazette notification.
Tender notice is 9/2/2021.
Yes, madam.
Tender notice. What is the defect here in page
Bakijai-
61?
It has to be for a specified period, my lord. There is no period, there is just written 1 year for the tender purpose and it is in the name of the president, my lord. This is to certify that Kusal Das, son of so and so. As per the,
Otherwise it is okay. Okay. 61. Some overriding is there.
yes, my lord.
He is secretary or what?
He is president, sole as president.
Kushal Das. President. Okay, next.
Next, my lord, is at page 64. This is
This is called what? 100%?
it's 100%.
SC, fisherman.
SC.
Fisherman.
Yes, my lord, but it is by some Anusita Jati Purikot, and it shows, my lord, that majority are scheduled caste. Not all. It mentions that majority are scheduled caste.
And it is to be by ARCS, right?
Yes, ARCS.
Okay. Anything else?
Then apart from that, my lord, the audited balance sheet, they have given only for 2 years, my lord.
Which one?
Audited balance sheet starts from, my lord, page 66 onwards till page 69.
But it is a fishery registered society, registered fishery society.
Yes, but even then they have to give it, or be as per the
No, it is to be given by competent authority in the cooperation department.
balance sheet. But
CA cannot give.
That is true, my lord. CA cannot give.
CA cannot give now, page 66, because if it is self-help group or NGO,
Yes, sir.
CO can give, CA can give. But you have not. This has come
No, I
to your knowledge for the first time.
no, I have
Right.
mentioned it, my lord.
You are about that 3 years.
I have mentioned it for 3 years, my lord.
If I
Because this-
remember correctly,
But this development
requirement
is-
is 3 years.
Yes,
But this is also defective
yes, my lord.
by
That is-
CO, CA, not by auditor of cooperative society.
Yes, my lord.
Okay, this is
This is the actual, the audited balance sheet, my lord.
audited balance.
And lastly, my lord,
Audited balance sheet for how many years?
so it has to be for 3 years,
For 3 years, not submitted.
not submitted.
How many? 2 years.
They submitted for 2 years, my lord. And that too by the CA1.
Where is 2 years?
Page 67 for 31st March 2020,
31st March 2020.
and the next page is 31st March 2019.
Silva, Ankita, proprietor. Balance sheet. One is balance sheet. The other one is
One other one is, my lord, income and expenditure for 31st March 2019,
whatever, ultimately it is not 3 years.
not 3 years.
Okay. Yes, any other?
And lastly, my lord, is the neighborhood, my lord,
Page?
at page 76, my lord. The clear indication as regards the specific distance has not been mentioned, my lord.
Now, Mr. Setia, whether these documents 60 at page 60, 61, 64, 66, and 76, those were submitted by the respondent number 7. Records?
Yes, I have the.
You have the records. Have you tallied? Have you tallied the documents?
Yes, madam.
I'm not going to tell you.
Yes, madam.
Mr. Khaun or Mr. Sharma, you check. Whether you have submitted, Mr. Sharma, whether you have submitted any other document than the ones annexed to the repetition. These are the documents. There is no dispute about it.
So we have submitted an RTI application at page 53, and accordingly they handed over the documents.
Anything to be submitted, Mr. Sharma? So, Mr. Khan, let me have, almost hearing is done, let me have a read of this judgment running into so many pages. This division bench judgment. Otherwise, I'll find out the other part which have already been dictated. Then we'll decide. Not the data, dear. Who is enjoying?
They are enjoying.
No stay.
No stay.
হ্যাঁ ও বন্ধ হয়ে আছে না আবার কি Can it be 12? Many holidays are in between. Or Mr. Count. Submissions were recorded
Yeah.
Yes, because we were awaiting the division bench judgment. So I'll find out the earlier part, then we'll proceed from that. In the meantime, let me
Yes, madam.
go through the judgment of the division bench. And if by 12, the Honorable Supreme Court decides otherwise, that is a different ballgame altogether. Heard Mr. S. Count. Learned counsel for the petitioner, M. Chetia, learned Senior Government Advocate Assam. For the respondent number 1 to 6, and Mr. A.C. Sharma, learned Senior Counsel assisted by Mr. S. Das, learned counsel for the respondent was second. Mr. Khan,
Yes, madam.
now I think this division bench judgment, that is why I need to go through, because division bench judgment says in what context, I don't know. Para 68. Para 68.
It starts with what? Paragraph.
In the instant case, the settling authorities.
Yes, madam. Paragraph 71.
Now, I suddenly remember. See, under the
Under the aforesaid principle. In this case, present case.
under the aforesaid principle,
Yes, madam.
what would be impermissible
Yes, madam.
is that if the authorities are not following the provisions of the notification, right?
Yes, madam.
It would not be open for the tenderers, it should be tenderers,
Tenderers.
to seek for an enforcement of the provisions. But the reverse would not be applicable if the tendering authorities are following the provisions. The same warrants and interference on the principle of the provisions of a notification being not enforceable.
Well, in the present case at hand,
They have not followed.
the tender notice is as per the gazette notification, madam. All these stipulations.
Oh, nothing is there.
Well, because if my lord.
Conditions are there.
Yes, madam.
Specific conditions are not there.
Because if.
See the division bench judgment, the
Mhm.
ratio.
Yes, madam.
Under the aforesaid principles, what would be impermissible
Yes, madam.
is that if the authorities are not following the provisions of the notification, it would not be open for the tenderers to seek for an enforcement of the provisions.
Yes, my lord.
Right, stop here.
Comma, but
Stop here.
Yeah,
This
yeah.
is one part. So you cannot enforce the provisions of the notification. If they have gone somewhere else, they are not strictly following the notification,
that is true.
right? Next, but the reverse would not be applicable that if the tendering authorities are following the provisions, the same warrants an interference on the principle of the provisions of a notification being not enforceable. That I have not understood.
Now, what has happened, my lord, in this,
What is the stand of the state in the affidavit?
in the affidavit, in this case, my lord, affidavit, my lord, they have taken the stand that the
Any mention about this notification? See, it has become more difficult now. I cannot say that it is directly binding.
well, in another case, my lord, they have said that any tender after the gazette notification, it has to be followed. The gazette notification has to be followed. It cannot be said that the tenderers are not, they do not have the knowledge of the gazette notification. There is one judgment, my lord. I had placed the judgment. That is the stand of the government, my lord. That after the gazette notification, all the tenderers, they must have the knowledge that there is a gazette notification and the tender has to be submitted as per the gazette notification. That is a stand, my lord. That judgment,
They
my
are
lord.
not following anything firmly. Problem there is that this is the observation.
That was in my lord. In the Tetiliaguri case,
What
my
is the
lord.
affidavit of the state?
In the affidavit regarding notification, nothing has been.
You are silent.
It's silent. madam.
They take their stand according to their convenience. If the selected bidder is to their liking, they will
That is,
ban
that is the reason why this court has to.
ban the thing.
My lord, if my.
That is why, in spite of this gazette notification, they are not bringing this thing as part of the tender notice.
I mean, in another case, my lord, I had given that judgment, my lord. The state government has, this council of the state has taken the plea that Mr. Sharma under state council has stated
Council has taken the plea, whether state has taken the plea.
that a gazette notification is of the year 2018 and the NIT is of the year 2021. And therefore, it cannot be assumed that all intended tenderers are not aware of the requirement of law. However, taking into consideration, this court also cannot ignore the condition of the gazette notification, which requires that all ensuing tender process have to incorporate the conditions given in the gazette notification, which admittedly has not been done. Is it right?
There
Your-
could be many theories in this account,
Yes, my lord.
but question is whether state government has taken that
In the affidavit,
stand.
in the affidavit, they are
They are
silent.
silent. In any other case, they have taken the stand,
Yes, my lord.
but that is council,
No, it's part of the judgment, my lord.
maybe, but council has said.
For the,
Council's thing cannot be binding. Submission cannot be binding unless it is advocate general, right?
it is part of the judgment, my lord.
Part of the judgment is different thing. You cannot put this thing as binding to me. It has to be, the stand is to be by the state government or by, if the advocate general makes a statement before the court, it becomes binding on the state government. But any council, learned council makes a statement, a submission that this would be the stand of the state government, that will not be binding on the state government. They can take other pleas in subsequent cases because on the premise that that is not binding. Show me any affidavit in anywhere
I
the
have-
state, the commissioner secretary, fishery department has said that after publication of notification is state government is following anything,
Let it come up on 12 September. In the meantime, I will.
anything, because this statement makes it difficult
Yes, my lord.
to make it directly applicable
Yes, sir.
in each and every case. Am I clear?
Yes, my lord.
I thought that on simple reading, I thought that it is directly applicable.
But
Okay. Anyway, we'll decide.
yes, my lord.
Anyway, whatever is
But
there.
one thing I need to point out, my lord, is that because we have taken a specific plea in our pleadings that it is enforceable. And since they are silent, my lord, the government is silent about the gadget notification. There has to be specific denial, my lord. Since there is no specific denial as regards the enforceability of the,
Just because you make a statement enforceable,
because-
does not make it enforceable.
because there is no specific denial as regards the non-enforceability of the. gadget
There are two
notification.
things which makes it enforceable. Otherwise, the guidelines are there. But see the condition in the notification itself. Yes. Clause 1,
Yes, my lord.
there is no due notice on the part of the for the bidders. Clause 1 in bold,
Yes, my lord.
that is the difficulty. Perhaps state respondents, state government is playing hide and seek in fishermen. There should be clear direction to the deputy commissioners, make this clause, notification part of the tender notice. Then everything, every litigation will come to an end. But that is not for the interest of Mr. Chetia.
But it was marked to all the deputy commissioners, my lord.
Marked,
Page 52, my lord.
but nobody is. Well, for further. Anyway, we'll decide whatever is there. I could have dictated, but had I been able to locate the other part.
Yes, ma'am.
তো ফালতু পেটা উলাই দিছে নে ফালতু পেটা উলাই দিছে Mr. Chetia, you find out what is the status of the Supreme Court case till 12th. Notice was made returnable till when? Yes, yes.
So this item number 1.
Yes, Mr. PP Medi. PP Medi.
No, Lordship, I'm S.A. Chaudhary, appearing on behalf of Mr. P.B. Medi.
Okay,
Lordship, I'm
Mr.
sorry,
S.A. Medi.
No, sir, S.A. Chaudhary, S.A. Chaudhary.
S.A. Chaudhary, Learned Counsel,
Lordship.
representing Mr. P.P. Barua, Learned Counsel for the petitioner has submitted that the petitioner does not want to
PP.
raise the repetition. No stuff. Where is Mr. Gugoi? R. Gugoi. Please call R. Gugoi. Your excise. Ah, Mr. K.P. Pathak, Learned Standing Counsel, Excise Department. For the respondent, state respondent is present. In view of the above submission made by Mr. So-and-so, Learned Counsel for the petitioner, the repetition is dismissed and withdrawn. Same order in all the 5 cases. 5 cases withdrawn.
Lordship, obliged.
Yes.
Please, your lordship.
Make this. Well, this matter relates to tenders for hiring of service provider for maintenance of biomedical equipments in medical colleges, district hospitals, and primary health centers. Now, the challenge made here is the minutes of the meeting of the evaluation committee, where the petitioner has been found to be not technically responsive. And the private respondent has been found to be technically responsive. I'll show your lordship, my lord, how the respondent number 5 could not have been held to be technically responsive because they did not fulfill the criteria laid down in the NIT.
Yes.
Now, although there are my lord, two NITs,
Two
But the-
NITs.
two NITs, but the minus of the meeting is one, and therefore my lord, one writ petition has been.
Where are the two NITs?
The first NIT is at page 35,
35. Yes.
and the other NIT is at page 106. And minus of the meeting
106.
of the tender evaluation committee, your lordship will find at page 325.
Let me mark this. What is the difference between the two NIT?
One is for the, my lord, the medical colleges, the other is for the district hospitals and primary health centers. Otherwise, my lord, the conditions are perimetry, exactly same. My. May I take your lordship to the, my lord, one of the NITs at page 35.
Yes.
And I'll point out the relevant clauses which requires your lordship's consideration. The relevant, my lord, page 35, 37.
37.
The NIT has been issued by the Mission Director, National Health Mission.
Yes.
The National Health Mission has filed the affidavit. The private respondent has also filed its affidavit, and petitioner has given affidavit in reply to both the matter affidavits in opposition. And thus the matter is ready for final disposal.
Okay.
May I read it, my lord, only relevant parts. For hiring of services, service providers for biomedical equipment maintenance and management program in the medical colleges of Assam, national competitive bidding. Your lordship may skip the other not relevant part for the time being. Page 44. The last but one paragraph 2.22.2. The online submission of documents is in two parts. The first part is the technical bid. The technical bid documents required shall be uploaded in PDF format only. The second part is the price financial bid, which can be uploaded in Excel format only. The BOQ document uploaded by the tender inviting authority shall be downloaded and filled. This is the my lord. Now, your lordship may kindly come to the eligibility criteria that your lordship will find at page 45. Required proposals, technical bid, financial bid. Then a pre-bid meeting was also, my lord, arranged. I'll come to that a little later, my lord. Eligibility to bid. The bidder may be a sole bidder. This is important, sole bidder or a group of companies, maximum 3 coming together as consortium to implement the project. Now, this clause, particular clause regarding sole bidder or a group of companies coming together as a consortium, that has been, my lord, amended by corrigendum. I'll show that a little later on, my lord.
Corrigendum at page.
Corrigendum will be at page 180.
Okay. Yes.
Corrigendum number 1. For hiring of service of so and so, your lordship may,
Are you reading Corrigan now?
yes, my lord. Page 180.
You can go on your own way, just I have noted down page number.
Yes, my lord.
Not to travel to Corrigan now. You can go on your own way.
Yes, because that is not in dispute. If only a sole bidder can apply.
118 is different thing otherwise.
Yes.
118.
180.
181.
180.
180.
That is the corrigendum, where it is said that it is not, consortium cannot participate, it has to be sole bidder.
Okay. 45, page 45.
Page 45. This is one important requirement, technical capacity, under the heading eligibility to bid.
Hmm.
The bidder should have at least 4 financial years of experience till the date of bidding, maintaining all biomedical equipment at different district, state, country. Work satisfaction reports from competent authority must be submitted. The bidder should be able to give evidence of the existence of a centralized call center and capacity adequate to meet the complaint, so and so. Now, this is important. 4 financial years of experience. I'll demonstrate from the documents that the private respondent does not have this 4 years of experience and does not qualify this eligibility because the experience that has been shown to be its own is actually a consortium experience. So on that ground, I am challenging the acceptance of the financial technical bid of the private respondent. Then your lordship may come to the last sentence of this page 45. I'm skipping, my lord, this is not very important. The bidder must equip the trained biomedical, clinical engineering human resource with required vehicles to reach out to the sites, as well as vehicles to carry tools and equipment and to and from the site. The bidder must have minimum 100 numbers of experienced biomedical engineers in their payroll, and evidence of PF, ESI payments are to be furnished. The petitioner's bid has been, technical bid has been rejected on the ground that the petitioner does not have 100 number of experienced biomedical engineers on its payroll. This is the sole ground on which my bid has been rejected, and the bid of the respondent number 5 has been accepted, although it does not fulfill the eligibility of having 4 years experience as a sole bidder. This is the crux of the matter. Now, my defense to this, Marat, I'll come to the documents a little later, Marat. My defense to this is that I have got 3 arrangements with 3 service providing companies which have all this requirement. I have agreement with them, and therefore I can provide 180, although you need 100, I can provide 180 trained biomedical engineers. That is my defense. Now, what happened, my lord? As your lordship has already seen, there was a provision for a pre-bid meeting. That pre-bid meeting was attended, and in the pre-bid meeting, this requirement has not been, my lord, insisted upon. I'll also show, my lord, in the document, in the tender itself, there has been, my lord, liberty has been given, some freedom has been given to the participants to arrange for human resources from other sources. I'll come to that. The relevant clause for this purpose would be page 50, clause 4.2.7. Yes. 4.2.7 at page 50. The service provider shall be required to deploy adequately qualified and trained staff for delivering the maintenance services. Name of the key officers of the service provider as stated in the district level, biomedical engineers, technicians hired for the purpose, and any other purpose which is a part of this agreement must be given to the contracting authority. Any change in the team should be notified to the contracting authority promptly. The human resource hired by the agency, here this is important, the human resource hired by the agency must have an adequate mix of technical and professional skills to ensure that they meet the contract goals, customer expectations, and quality maintenance. Now, my lord, to bring home my point that the freedom has been given to hire services from other providers, besides this 4.2.7, I'd also rely on clause 4.2.18. 4.2.18. Before that, my lord, your lordship may at page 50, my lord, some statements may be my lord noted at page 50. I'm coming back to page 50 again for the purpose of clarity, because my lord, this has been clarified that the service provider can deploy adequately qualified trained staff. Then for purpose of clarity, may I read it? Operationalization will be regarded as setting up a maintenance workshop for maintenance of medical equipment and maintenance activities conducted on biomedical equipment, setting up of customer care center to accept the user calls, register, these are the requirement, appointment and recruitment of trained engineers. This is important. Appointment and recruitment of trained engineering and administrative human resource. What I'll try to impress upon your lordship is that although there is a requirement of 100 biomedical engineers, but at the same time, they have also given this liberty to recruit and train administrative human resources, and that the service provider shall be required to deploy adequate qualified trained staff for maintenance service. And then it's 4.2.13 at page 52. The responsibility of work of authority and service provider under the comprehensive equipment maintenance outsource model has been tabulated as below. Components, page 52. Components, authority and service provider, serial number 2, your lordship will find hiring of trained human resource. Meaning thereby that the service provider can hire and train human resources.
This is important. Second and third column, hiring of trained human resource authority, that means the NHM, they cannot do it. Service provider, they can do it, yes. Then your worship, page 54, 4.2.18, these are the terms and conditions. The relevant term is clause 4.2.18.9 at page 56. Page 56 is 4.2.18.9, general terms and conditions. I'll harp on clause D. The service provider will be responsible for procuring all the necessary tools, spare parts, manpower, vehicles and other services required for the satisfactory completion of the contract. Now this indicates the bidder's autonomy to procure manpower. Your Lordship may then skip the other pages. Your Lordship may come to page 61. Page 61 is the pre-qualification of tenderers. And this in pre-qualification, there is nothing, my lord. I can read the entire narration here. Your Lordship will find nothing where it is stated that 100 biomedical engineers are the requirement for in the payroll. Such requirement is only at page 46 that I have already shown your Lordship. But here in the pre-qualification of tenderers, that is not mentioned. Going by the, my lord, liberty and autonomy given to the bidders, so they can hire services. Now, page 63, these are, my lord, clause 6.1 is the contents of the tender documents. What is to be given in the tender document in submission of tender, these are there, my lord, these are not in dispute. Anything? This one. Yes. At page 70, your Lordship will find the parameters of evaluation.
70.
70.
Yes.
Clause 6.17. Evaluation parameters. The selection of firm will be based on quality cum cost-based selection criteria, where 70% weightage shall be given to the technical evaluation score based on the technical proposals submitted by the agency bidder, while 30% of the weightage shall be given to the financial score on the subject of financial. This, my lord, here there is a chart. Clause 6.18 is followed by the charts. Clause 6.18 says technical evaluation. Firms meeting the above eligibility criteria will be shortlisted and their technical proposals will be further evaluated based on the following qualifications. Firms scoring 60 and above will qualify further for opening of respective financial proposals. So on fulfillment of these requirements and on achieving these marks, the bidder will qualify for opening respective financial bid. Now, in this chart of technical evaluation matrix, serial number 2, your lordship will find the bidder should currently be employed on the rolls at least 100 biomedical engineers across the country. Then on the middle column, your lordship will find that less than 100 biomedical engineers, 0 marks. 100 to 157 marks, 150 engineers and above, 10 marks. Now, my submission will be, this will show that if I do not have 100 biomedical engineers, you can give me 0. If they're not in my payroll, you can give me 0 marks. Because, my lord, the target is to achieve that 60% mark. But you cannot reject on this count. In other parameters, I may have more marks, and on this ground, you can only give me 0, but you cannot reject me on this ground. Whereas, my lord, on this sole ground that I don't have 100 engineers, biomedical engineers on my payroll, my technical bid has been rejected. So these are the, my lord, relevant conditions so far as the petitioner is concerned. So far as the respondent is concerned, the clause regarding this. Oh, yes. The marks. Then your lordship may kindly come to page 180, that code is under.
Yes,
I'll show that. No, wait, let me show this first. Page 180, clause 2. Technical capacity under eligibility to bid, page 11, is amended and to be read as follows. The bidder shall participate as sole bidder and should have at least 4 financial years of experience in BEMPP at least 2 states. In continuation of the date of invitation of bid, maintaining all biomedical equipment, work satisfaction reports, and monitoring the years of service, so and so. Then next sentence, consortium bidding is not allowed. This is where the private respondent ought to have been rejected. Its bid ought to have been rejected. And this particular clause is there at page 117 also, my lord, that I have already referred to. Now, so far as manpower, in page 183 of this, my lord, the same document, your lordship will find there are marks. There is another chart of my lord, technical evaluation matrix at page 183. The technical evaluation matrix under clause 6.1.7 of evaluation parameter is amended and to be read as below. The earlier one has been, my lord, modified, amended. Here also it is all the same.
So this is the one which is to be looked into.
Yes. Next page, your lordship will find the bidder should currently be employing on rolls at least 100 biomedical engineers across the country, 10 marks. If it is less than 100, 0, 100 to 127, that remains the same. So this is not the, my lord, rejection criteria. These are the clauses which needs to be read and interpreted by your lordship. The second NIT is also, my lord, exactly same. There is nothing, so I'll not take your lordship.
Original is same.
Yes.
Original is also
Original
there.
is also same. Now, I would like to take your lordship to the 3 agreements that I have for providing this manpower. Page 269. $268 is the communication given by the petitioner to the mission director. We are enclosing the list of experienced biomedical engineers on payroll. The total number of biomedical engineers available having more than 3 years of experience is 188.
You are reading to
Page 268.
68.
268 is the forwarding letter.
Ah.
Annex 12. The last but one paragraph, we are enclosing the list of experienced biomedical engineers on payroll. The total number of biomedical engineers available having more than 3 years of experience of 188. Well, this was written because of the fact that the mission director asked for certain clarifications. Then we have given these, my lord, documents at 269. It's an agreement with the.
I don't think it will be completed today.
It cannot be, my lord.
What to do? Some other date.
Your lordship will kindly fix a date because my learned friend, my lord, he comes from outside to brief me from Bangalore. From Hyderabad, I'm sorry.
Yes, what is the present arrangement?
Present, there is a status
Is
quo.
a meeting.
My lord, presently, my lord, the earlier contract has been extended. The new has got started. From June, my lord.
Mr. Mohanto, you are,
I am not running.
you are private respondent.
I am private.
You are that other one.
Other one, madam.
Okay.
As per now, I-
Second week or third week. Your lordship may put it either in the second week or the third week.
Definitely first week up to 14th.
Okay, that'll be fine.
14.
Right.
Okay, hard. I was in video. Hard video. Mr. Chaudhary and Senior Counsel. Commissioner, Mr. Chaudhary and Senior Counsel for the petitioner remains. It is not concluded. It is the case again. It is the case on 14th for party.
My lord, can the liberty be given to us to at least, my lord, agree it, my lord, is possible, because we'll take some.
As on that, hardly 3 matters are listed as on. But we'll see, try to adjust this top of the list category.
Yes, my lord, all
Both are important.
lordship.
My lord, the interim order, status quo order is still today, my lord.
Okay, the interim order. বাকি নাম কি লিখি দিব দেই গোটেইকেইটা লিখি পেলাই তাৰপিছত এইটো লাইন লিখি দিব very hard remain is not completed. There is the case again on so the interim order comes out.
My lord, item number 8, my lord, the next one. Will your lordship fix a date? My lord?
You want to hear?
No, my lord. I pray for a day. Otherwise, it will not be listed, Lord.
Okay.
Number one of our.
Huh?
Number 8 here is interim lordship.
Interim of the trial. Okay, sign off. Mr. Pathak, due to paucity of time, I'll try to find out if it is possible, otherwise fix a date for delivery of order. Right? Yes, interim order.
No, yes, sir.
Continue to. Huh? Ask number 2.
আরেকটু বলবো